Morning, good morning, good morning. It's Wednesday, it's October 8th. It's time. Today we were going to catch up on all things plaintiff's attorney and ChatGPT and other things, but too much has happened in the Kouri Richins case for me to wait because I want to know, and because I know you want to know. We just have to do that. So first I have to apologize. I tried to wait out our lawn maintenance that's happening. So if you hear background noise, it's not at your house, it's at my house. When we said, if we can be done before 11, they said, perfect. And I think what they heard was if you could start at 11. So anyway, here we are. But cheers. I've got coffee. If you follow me on Instagram, you'll know what I have for breakfast. We're not going to have time to eat, I don't think, today, but we're going to try. We'll see. We might just need to take a break and have brunch together. I mean, we have so much to go over today. I don't know where to start other than to say, if you have not been following my coverage of the Kouri Richins case, now is a perfect time to jump in. We are going to cover a bunch of new filings and a new indictment in the Kouri Richins case out of Utah. She is the Utah woman accused of poisoning her husband with fentanyl, which is going to be a big part of today's topic because the defense is saying that the prosecution withheld information. We'll evaluate that motion together. They want her out on bail. She has been in custody for years now because there was a very long process to try to change venue that didn't get changed, and then trial got continued until February. And now there's new information. So we need to cover all of the new filings and the new indictment and all the things. So that's what we're going to do today. So we've got a quick update on another case y'all have been asking me about, but we'll do that first and then we'll get to this. My cat has been sitting on my desk for days. So there's fuzz. It's whatever. The Artful Colorist said, do we get to have a mimosa? You can pick whatever you want, whether it's a mimosa, whether it is a glass of champs with a waft of orange called a mimosa. There's no judgment here. Y'all pick whatever it is you like. So let's roll the intro and then we will get into it. Shall we? Shall we just? I think we shall. Let's go.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
Y'all, I know for those of you that are just coming in and missed my disclaimer about background noise, it should be done soon. I promise it should be done soon. I tried to delay. I was like, I can't delay starting anymore, but it's an ongoing issue at my house. We will sort it. Don't worry. Let me know where you're coming in from, what you're drinking. It's over here. But we need to do a quick case update because I've gotten a lot of questions about whether I'll be covering this case. And part of my very honest feedback was, it depends if this trial is going to conflict with BravoCon. And look, man, there are some priorities that we've got to adjust. And streaming on the road at BravoCon, I don't know. For those of you that don't love the Bravo sphere, it's like Comic-Con, but for reality television, Bravo style. It is so much fun. I enjoy going. I enjoy seeing everyone. I enjoy catching up. I enjoy sleeping, well, not nearly enough. And then trying to stream on the road is a mess. I'll be doing some members only stuff, but to sit down and focus on a trial. It's not going to work well for me. So with all of that, we need to talk about whether or not Emily is going to cover the Brian Walshe case. Look, I've told y'all we would keep an eye on it. I've told y'all I wasn't sure how the timing was going to work out. And I told y'all I wasn't sure if this was going to go to trial when it's supposed to go to trial at the end of this month. Well, guess what? It's not going to trial at the end of this month. So we can put a pin in it for a while and we can decide later. We can wait. But I wanted to explain what this means because I've gotten a lot of question about whether or not this trial is going to go and what's going to happen. So Brian Walshe says, why is everybody a Brian? Brian Walshe's trial for the murder of his wife postponed in wake of jail attack. Let's talk about this. Let's put this in reader mode real quick because I literally can't. Brian Walshe is accused of murdering his wife. The times you have heard me talk about this case, we have not gotten into the facts of the case. We have gotten deep into the discovery of it all because this is another Proctor problem case. This is another Proctor problem case. Brian Esposito in the chat said, not all Brians are bad. I know, I'm married to one. I know. But we have talked about this in the realm of Proctor problems, discovery issues. This is another Proctor case. So this is a Proctor problem case. And that's why we've talked about it. We have not talked about the, charges. We haven't talked about the investigation outside of discovery. We'll see when we get into it, but I wanted to answer some of these questions. Less than 1 month before Brian Walshe was due to go to trial for the murder and dismemberment of his wife. Look, this is another one of those Google search cases. A judge ordered that he undergo a mental health evaluation and the trial was postponed. The judge issued an order for a competency examination on Monday. The case docket shows this was last week, not this past Monday. Wait, was it this? No, it was this past Monday. This week, what day is it? It's Wednesday. That was this week. This week. The court did not release a copy of the order citing medical records. Yeah, it's a competency evaluation. We went through what a competency evaluation means when we talk about the Tom Girardi case. The title of the order cites a state law that allows the court to order an examination whenever a court of competent jurisdiction doubts whether a defendant in a criminal case is competent to stand trial or is criminally responsible by reason of mental illness or mental defect. Oftentimes, the defense attorneys will ask for this and say, I've been meeting with my client. I have a doubt. We have some problems. We need an evaluation. The final pretrial hearing was scheduled for Tuesday. That was yesterday, October 7th. It was rescheduled for another competency hearing for October 27th. They may not have the report back by then. So they might have to set it out again, but the trial was supposed to start October 20th. If there's a question about whether he can do it, it can make the entire trial invalid or create an appellate issue, says the attorney that the news asked about it. Trial was supposed to start October 20th. It's being rescheduled. There's no trial date now. So again, on a quick summary of the case from the news media, he faces charges of murder, misleading a police investigation, improper conveyance of a human body. His wife, Ann Walshe, a 39-year-old mother of 3 from Cohasset, went missing around New Year's Day, 2023. Prosecutors believe he killed and dismembered her before disposing of the body. Defense attorney Larry Tipton said in court that Brian Walshe's mental and physical health has declined since he was attacked in jail last month and is not well enough to participate in the preparation for his trial. The quote from the defense attorney is, the defendant has made progress, but both mental and physical effects of the violent assault have continued to prevent him from being able to adequately participate in preparing his defense. He's made great effort to do so, but at this time it is evident that the trauma resulting from the unexpected and sudden attack continues to significantly impact his ability to work with his attorneys in a manner required as his complex trial approaches. So they're going to send him out for an evaluation. They are going to need at least 20 days for an evaluation. Then they're going to need time to get that report back. So when we are looking at the Brian Walshe case, it is going to get set out for probably months and months, but we might have some resolution with Proctor before that. And as I see the mowers coming back around another time, this is probably a good time for me to take a minute to mute my mic and thank our stream sponsor. Not a smooth segue, but Breakfast of Champions today for me and most days from Wildgrain. So we're going to thank our stream sponsor and hope by that time we're done, the mowing will be done. And then we'll finish talking about Brian Walshe, who's definitely not getting delicious artisan croissants and and donuts in custody. So let's say thank you real quick to Wildgrain.
Leonard, let's take a minute to talk about the fact that I wish I had more time in the day. And you know that the sponsors I love working with make things easy. That's where today's sponsor, Wildgrain, comes in, because you can have all of the joy of delicious homemade pastries, pastas, and artisanal breads without all of the hassle, because they just deliver it frozen to your doorstep and then you just bake it. Freezer to oven, less than 25 minutes. Wildgrain ships you a fully customizable box of incredible artisanal pastas, breads, slow fermented sourdough, and more. One of the things I love most about Wildgrain is that you can just take a few out and bake them as you need them. I can pull out just a couple of the apple cider donuts, which are so fantastic, and not have to just bake all of them at once. So if you are ready to have some home-baked goodness without all the home-baked headache, it's time for Wildgrain. Be sure to click the link in the description or in the chat and use my code LAWNERD to get $30 off your first box plus free croissants for life. Don't miss out on their seasonal products. And remember, with every order of Wildgrain, they donate 2 meals to the Greater Boston Food Bank and other giving partners. So every time you see me eating something delicious on stream and you're like, Emily, what is that? And I tell you it's the Wildgrain croissants, it's because it's the Wildgrain croissants. And sometimes the donuts. So speaking of stream, let's get back to it.
Hopefully we are now, well, hungry, but also free of the background noise. The chocolate croissant is one of my favorites. Griffin loves the butter croissants. Dr. B and I, well, the entire family loves the donuts. We keep running out of them, so my freezer is very full. I really want to be a sourdough girly. Honestly, I do not have the patience, the memory, or the time to undertake that project. So I feel like I get to be a sourdough girly without all the other stuff. I get to put it in the oven, and then my house smells delicious, and then I take it out of the oven. And then I am excited. Plus, those who have gotten the gluten-free boxes, and occasionally we get the gluten-free cookies and what have you as well when we have gluten-free friends and family member visiting, they're fantastic. So if you're like, but gluten-free, but fantastic. Let's talk about, well, let's finish talking about Brian Walshe so we can move on and talk about somebody else with super sus Google searches who's accused of killing their spouse. Emily, what light, happy topics? I thought we were going to talk about attorneys getting what's coming to them. I know there was just so much going on. I couldn't wait. The ADHD pulled me in a different direction. Let's finish up talking about the Brian Walshe case. We'll get back to this another day because, look, the attorneys are saying he can't help prepare for trial because he was attacked in custody. He was attacked and stabbed. He went to the hospital. Let's talk about that real quick. Look, custodial settings should be safe. They are not always safe. People do get shanked in prison. Should they? No. Do they? Yes. Most, once they are patched up, continue to go to trial. I think the YSL case, one of the defendants had gotten attacked in prison and was in the hospital for multiple weeks and was like 2 days out of the hospital and back in court. It was wild. But he has recovered. He is going to need to move forward with trial. But this delay of the trial might also help the defense attorneys in their fight to get the Proctor text messages. And at this point, if the court is like, look, if you need more time, you need more time, it's frustrating for the prosecution. I gotta be honest. I give a lot of prosecutions the benefit of the doubt until my trust is burned and then you're dead to me. I don't have a lot of empathy for the prosecutor's office in Massachusetts. It's frustrating when a trial like this gets postponed. But you know what's more frustrating? Not having discovery turned over. So like, too bad, so sad. It's going to be frustrating for them if the defense needs to postpone this and get their discovery, and this is the reason why. I mean, fine. It's real annoying for the prosecutor's office, but like, deal with it. I can't get fussed about it. They just don't turn over discovery in a timely fashion. So I'm not so sad, you know? Angie B said, wouldn't he be in the jail, prison, infirmary? They normally get sent out, depending on the custodial setting, they will get sent out to the hospital. And then after they're released from the hospital, be back. But he's saying that the trauma of the thing is so much that he can't help his attorneys prep for trial. Look, Tom Girardi was found competent. I would be shocked if Brian Walshe was not found competent to stand trial. However, if there is something that is at the moment has shifted the way that Brian Walshe is able to help his attorneys, that's something that can pass. They might give him time. So it might just be he needs another 2 or 3 months, and the court will do that. But I don't think this is going to be a situation where he's declared not competent to stand trial and then he never goes to trial. That's not his circumstance. This is a temporary blip, if they even find that, because the level for competency is incredibly low. And then when they're talking about whether or not he was able to perceive the crime when he was committing the crime, that's a totally different conversation. And even when we were looking at a case like the Shabusiness case, she was still found to not be acting under mental disease or defect. So those cases are rare. Competency is, can you help your Can you help your attorneys? And it might be that he's under so much stress because of this attack that he can't for the next 3 weeks. Okay, fine, then they'll continue it. So we'll see. But this can be something that can be restored. So even if he is found not competent currently to stand trial, which I think we'll see. But even if that is found, it's something that can be restored. So it would be a matter of how much time. It's not a matter of Brian Walshe is not going to trial. So Brian Walshe, for those of you just coming in, was attacked in custody and was stabbed. He is recovering, but his lawyers say the stress of that attack has made it so that they can't go to trial. Oh, for those of you that complimented the shirt, thank you. I was shopping some deals on Amazon. It is a very lightweight flannel. Otherwise, I wouldn't be able to flannel today because it's just not warm enough. So I'll link it, but it's Amazon Basics. Like I am. When I'm looking for like 100% cotton clothing, Amazon Basics is one of the first places I check. Look, it's going to be like Amazon or Target or Costco or like Quince. Emily, where did you get that? 7 years ago. From Target. Okay, let's continue on. The defense attorney is being quoted as saying the competency hearing was one of several new elements added to the case docket Monday. Oh no, that's the end of a quote. My brain didn't splice it properly. Apologies for the ADHD dyslexia. The media continues, and this is WCVB. The competency hearing was one of several new elements added to the docket Monday. That was this Monday, October 6th. Others include a series of responses from the prosecution to recent motions submitted, which are needed because there are still issues regarding discovery. And the other docketed items, includes a response to Brian Walshe's request that the judge prohibit testimony alleging he knew about his wife's extramarital affair prior to January 1st, 2023. Is that part of what drove his rage? According to the response, the prosecution expects to present evidence that will, quote, permit a reasonable inference about his knowledge, but does not intend to ask any witness that question directly. The prosecution emphasizes that they do plan to introduce that a private investigator was hired to look into Anna's infidelity. Sir, fucking miss me. If you hired a PI to follow your spouse to see if they're cheating, what you don't get to do is go to court and be like, I had no idea. Miss me. Miss me. Miss me. I don't want to hear about it. I don't want to hear you complaining. Prosecutors also responded to a request that the judge prohibited information about Brian Walshe's prior legal and criminal trouble. Honestly, I'm really interested in that. Grayspace in the chat said his mom actually hired the PI, but how would his mom know? Okay, is his mom's name Donna Adelson? How would his mom know? So, oh, my mom hired the PI. Okay. Sure. Donna. I mean, it's fair. Emma Mack said, I mean, mother-in-laws can be cray-cray. They be doing shit sometimes. It's fair. It's just, I have questions. I just have questions. So we'll see. Prosecutors responded to a request that the judge prohibit information about Brian Walshe's prior legal and criminal trouble. I got to be honest. I know we've covered a lot of murder cases. I'm interested to know more about his federal art fraud case. We haven't gone over the background of this case. We will at some point. I'm really interested to know about the federal art fraud case. Really, I'm interested. Do we have a money laundering situation with the art fraud? Because art fraud is often money laundering. I'm curious. So when we go over this, part of what we will talk about is that federal art fraud case, and if this is part of what was this the tipping point that went down the rabbit hole here? So I'm curious. I'm curious about the federal art fraud case, honestly, and then we'll see if we get into this, but it's going to get continued. It's been continued. We'll just put him on the docket later. Like, bro, can wait a minute. The discovery situation, I'm very interested in. So that is something I can't look away from because it's all the same cops. Like, it's all the same cops that are involved in the Karen Reed case. And I feel like as much as we're catching EDB air out of Massachusetts is like, the fuck you are. Come on back. You know you want to know. You know you're curious. You know you're curious. Susan Lohr said, who would assume any artwork on eBay is legit? This is very fair if he's selling Warhols on eBay. It's like an Animal Crossing when you have to go buy the art and you've got to determine if it's real art or fake art. You got to just see. All right. Are we ready to catch a flight to Utah? Are we ready? Are we ready to Utah? I think we're ready to Utah. I think so. I'm ready to Utah. You're ready to Utah. Let's go to Utah. I know we were supposed to be dealing with lawyers behaving badly. The ADHD really wanted to cover this today. So we're going to talk about Kouri Richins. Let me put up a poll in the chat. I'm really curious. Wait, Miguelina, Team Baker, it's in the chat. Like when I go to pull up start a poll, it says I can schedule a members only live stream. It's in that window. YouTube's doing new things. We might have to try that out today. Let's see if I can zoom. We might have to try it out where we can make the live stream turn into a members only. I might have to just play with new things. Like there's new stuff in the stream like center as well. Like YouTube's rolling out all kinds of new stuff. Damn, Emily, no, focus, distractions. There's new distractions. We might have to play with that later. Okay, don't hit that accidentally. I'm just trying to start a poll. We might have to try new things. We're gonna have a members only later this month, but we might have to just test it out because I'm curious. Like full squirrel moment. We can't do it now though because we need to talk about Kouri Richins. This is a quick poll. I'm gonna ask if you've been following the Kouri Richins case when I put the poll up in just a second. The Kouri Richins case, she is accused of poisoning her husband with fentanyl. She wrote a children's book about it and was on book tour when she got arrested. And she wrote the Walk the Dog letter. I won't make the stream into members only until we're done. Joanne, I promise. We're gonna finish the stream. I'm not gonna do it right now. We might do like a after party. Don't worry. We're not gonna do it now. I'm fighting the ADHD urge to play with new things. So that is the Kouri Richins case. Let me know if you've been following it. Wherever, however, wherever, whenever. Because some of you don't know this case. Some of you do. Let's fly to Utah. We're going to hear more about Google searches today. You know why? Because there's a new indictment and it's so many pages. We have so many filings to get through. And then before the end of stream, I'm going to do what I always say I'm not going to do. I know I'm going to do it. I'm always like, Emily, you don't have time to do this. And then I do it anyway. I don't have time, but I'm going to do it anyway. I'm going to check the docket because I really want to know if the prosecution has responded. And the docket in Utah is not the most easily navigated docket. So we're going to navigate the docket later today and see if the prosecution responded. We have so many filings. We need to fly. Let's go to Utah, law nerds. Yay, Utah. What's up, everybody? If you might have seen Kouri Richins in the news or her lawyers in the news because her defense attorneys are defending the accused shooter in the Charlie Kirk case. I am not covering that case. However, you are going to see conversation about Kouri Richins' attorneys because they are also the defense attorneys in that case. So that's it. Originally said, what are the snacks on EDB Air? Today, it's croissants from Wildgrain, but it's dealer's choice. All right. So I will check the docket before we leave today. Let's do a quick road so far on the Kouri Richins case. We just flew, so we're not going to swoop or whatever. Kouri Richins is accused of poisoning her husband with fentanyl when she was in the middle of significant financial trouble, like girl boss too close to the sun. This case was filed on May 8th, 2023. She was arrested on May 8th, 2023. The murder happened on March 3rd, 2022. There is also an attempted murder charge. That is charged from February 14th, 2022. There's a lot more detail in it. We will get into it through the course of these motions. This was originally set for trial, and then it got continued for a ton of motions and an appeal to the state Supreme Court. The state Supreme Court twice, actually, it went up. They took one of them. They didn't take the other one. They were trying to bring in a bigger jury veneer. They were trying to change venue. Much happened. It was all denied. We're back in front of Judge M and his fabulous beard and his deep, spicy novel-esque voice. I'm sure he's thrilled with us for that. This is also the case where Brad Bloodworth, the prosecutor, was talking about Docket 214 because Docket 214 is the walk the dog letter. And in court, they've talked about this channel a few times, not by name, but in court, the prosecutor said, you might remember this.
But every law nerd on the internet calls it the walk the dog letter.
Yeah, that's Docket 214. Look, Judge M, we love you. The law nerds don't fuck around. The law nerds are not the side of the internet you're looking for when you're annoyed with the internet. It's not the law nerds. We're not the problem. We are not the ones. We just want to watch. We're not gonna cause trouble. We don't go real world. We don't tap the glass. We would never. The law nerds are the people that are like, hey, don't do that. You know, we've got you. We've got your back, Your Honor. We just want to be able to watch it streaming. That's all. We just want to see the evidence. And now that the defense is saying that maybe the prosecution is withholding evidence, we really want to know what's happening. We want to know. We want to make sure that prosecutors are doing what they're supposed to be doing. We want to see good lawyers do good lawyer work. Nobody needs the Emily rage when lawyers act wild. It gives me a headache. The bad lawyering in the Cardi B case, not Cardi B lawyers, the plaintiff lawyers, I still have a headache. I still have a headache. from that attorney. Because the fuck. We just want to watch. We want to see lawyers do their work, Your Honor. We just want to see justice. We're big, big fans of justice. And there's something so vindicating when you watch a trial and you agree with the verdict and the verdict comes in and you're like, yep, let's go. Let's go. That's exactly right. Let's go. Absolutely. All right. Let's continue. We have many documents to go over in the Kouri Richins case today. Let me just grab them out of my folder that I had all tabbed, then all my tabs crashed, and here we are. For those of you that have been following this case with me, and that's about 80% of you, a lot of you haven't heard of this case before. Google will get you is like not legal advice, just practical advice. Google will get you because the Googling in this case is wild. We'll hear about it in the fourth indictment in this case. This is the fourth indictment in the murder case. We have also covered the indictment in the separate fraud case that was filed later. That fraud case involves the mortgage fraud, the forgery, the life insurance fraud, and the rest of it. So there are 4 cases technically going on with Kouri Richins. 2 of them are cases regarding the estate that actually ask some very legally interesting, factually enraging questions, because legality and morality are not always the same thing. The legal questions are, hey, is Kouri Richins entitled to her deceased husband's estate if she did in fact murder him? And can she get those items? And what, if any, aspect of the estate is she entitled to? So she and her sister-in-law are fighting over the estate in 2 different cases. Then there is the criminal murder case, and then there is the criminal fraud case. The prosecutors have separated things out. The judge separated part of that out. So we're not going to get like a murder fraud within a murder trial. So that's what we're not going to do. For those, a few of you have asked about my mic. It is background noise. It's not the mic. It's landscaping. I said before 11 and they started promptly at 11. And I tried to write out the worst of it before I went live. So mods, I'll let you guys answer those questions. But yes, that's the background noise you hear. I keep saying it should be done, but then it's not. So in the meantime, there was a status conference in August. The prosecution and the defense had been working pretty well together. The defense is defense attorney, but they do it reasonably. They're like, well, Your Honor, can we get their discovery? We want their witness list, but we don't want to turn over ours yet. We want their exhibit list, but we don't want to turn over ours yet. They're doing their job. There are times they ask for things that make me roll my eyes, but they're doing their job respectfully and professionally, and I appreciate it. There are times where I'm just like, that argument is extra, but then they're doing their job, and I appreciate that they're doing their job, right? These defense attorneys and prosecutors have worked really well together. So I am surprised to see allegations that the state did not turn over evidence. We're going to evaluate that today. The first motion, so we're going to go back to the first motion in this new series of motions. They were just in court in August, and then they have been working outside of court on getting ready for trial in February. Part of the reason this is going to trial in February is because the court and the attorneys all agreed that the case needed to be put over, but then they were also trying to get out of all of the difficult jury selection time. Hey, if we go to trial in November, it's Thanksgiving, and everyone gets feisty and jurors don't want to be here. Then we have days off for Christmas. The defense attorneys had another federal trial in October. Then it's the holidays. Then it's January. Then there's like a ski week that Utah schools have. And they're like, look, if we try to have this trial over ski week, we are in the very real possibility of having jurors whose kids are out of school, and that becomes a whole thing. And I'm like, Utah, right. Ski week. So when they set the trial to try to find the window of time between ski week and spring break for the kids. I suspect that the judge probably has children in school as well. And I suspect some of the defense attorneys might, because they were very mindful of the school schedules. But it's also the number one thing that yeets jurors is, look, we've got all these things going on with kids and we need them to have time. They have a ski week. It's Utah. I don't know. We have a fall break week this week for our kids. We had ski week in my school district in Southern California. And I think it started because so many parents took their kids out of school. They're just forget it. We're just closing for the week. Everybody's going skiing fine. It's the bougiest shit ever. Of all the bougie things I didn't do growing up, the bougiest thing my family did was enjoy skiing. My mom still loves to ski. My mom loves to ski. I married Dr. B, and Dr. B's like, hey, so I'm a dentist, and if I fall and break myself, I'm super fucked. And then I tore my rotator cuff, and then I herniated my back, and I was like, I'm not hurling myself down a mountain. So that is when skiing kind of ended for me. But I totally enjoyed it. But it is some bougie shit to have a ski week, for sure. Some of you are saying we have breaks for different things. I love that you guys are sharing the breaks that you have for school. Gabby's like, we have a rodeo break in Arizona. That makes perfect sense. Some of you were like, look, we're out of school for Mardi Gras in Louisiana. That makes perfect sense. It's just really about the availability of people to do things, right? So Emily Jane said, wasn't there a ski week episode of Saved by the Bell? There probably was. We used to go on, the school would take ski trips to the local mountains. I don't know if schools still do this. I imagine the liability waivers are insane. But we would go on a day ski trip with school. Look, there are things I don't want to do as an adult. Going up the side of the mountain in a bus is one of them. I'm way too motion sick for that. Yeah. And then hunting week, depending on where you live. Look, for people who are like, the US doesn't even make sense. Correct. Correct. It's just, depending on where you live, there are so many different things going on. It is very regionally specific. So ski week in Utah. Kylie says Tahoe has ski week, so we avoid skiing that week, which makes the most sense. It makes the most sense. All right. Also, Judge M is on the Utah Avalanche Committee and stuff. I'm fascinated by Judge M's background, but we'll talk about that another day. Fascinated in a good way, because fascinated in a good way. Let's see. Where I was just going to grab this. WW said must be an LA thing. We never had ski trips in San Diego. I imagine it would take a lot longer to get from San Diego to Big Bear. From LA to Big Bear wasn't so bad. You could kind of do a day trip. It started at 4 a.m., but it was easier. All right. Are we ready, chat? Let's officially start. Let's just officially start, shall we? Shall we just? We're going to officially start talking about the Kouri Richins case. This is why we timestamp. Emily, what are we talking about? We're talking about all the things. It's fine. The first motion we have is a motion to appoint counsel for a witness. Anytime you see motion to appoint counsel for a witness, you know that there is stuff happening, right? Because why would a witness need an attorney? So, let's take a look at that first motion and embiggen just a little bit. You guys, aren't documents so much easier to see? Isn't it just great? So this is the defense motion. It's just, the documents are just so much better. Just so much better. Emily said, Judge M controls avalanches with the power of his voice. Stop. In the name. We're going to have to go through all the different stops today. Stop right there. Thank you very much. Stop. Hammer time. We could do an entire mashup. We're not going to. We're going to talk about this motion. The state has provided in discovery the statements of several potential witnesses relating to their participation in the alleged unlawful distribution of controlled substances. These witnesses have also been identified as likely witnesses at trial due to their inclusion at the state's request in the jury questionnaire. To date, the defense is only aware of one of these witnesses being granted any sort of immunity. The remaining witnesses face potential state and/or federal criminal liability if they take the witness stand at trial and testify consistently with their statements produced during discovery. In order to protect their liberty interests, these witnesses should be appointed counsel to advise them of their Fifth Amendment rights. The defense. Your Honor, excuse me, Your Honor, can you please appoint lawyers for all these witnesses to tell them that they should assert their Fifth Amendment rights so they don't have to testify? Please? Can you tell them that? That would be great. Thanks, Your Honor. So the can you give them lawyers to tell them they don't have to testify? The judge could decide this on their own. However, the defense is asking for this to happen for multiple witnesses. It's important for these witnesses to be appointed counsel prior to trial in light of the Utah Supreme Court's ruling that, quote, a lawyer conducts himself unprofessionally when, for the purpose of impressing upon the jury the fact that the claim of privilege, he calls a witness to testify when he knows the witness will claim a valid privilege not to testify. I don't think these witnesses are going to do that, but okay. The defense has said, Your Honor, we're not trying to stop witnesses from testifying. We're doing our legal duty. So this is couched under we are doing our legal duty. That's from State v. Travis, a 1975 case in Utah. They go on to say, without the assistance of independent defense counsel advising the witnesses, there is no way for defense counsel to avoid this trap. I mean, if they're on the state's witness list, it's really the state that would bear this burden. They go on to say, furthermore, defense counsel may be entitled to assert unavailability of the witness if they have advanced knowledge of the witness's intent to assert their Fifth Amendment right and can then subpoena the witness to appear before the trial judge to assert the right. An unavailability determination may lead to pretrial admission of otherwise inadmissible hearsay critical to the case. Appointing counsel prior to the procedure will serve the best interest of the judicial economy by avoiding having to come back for a second appearance. And then they list the witnesses that they think may need attorneys. Your Honor, they might need to plead the Fifth because they were like involved in potentially illegal activity, and they're going to potentially testify to the fact that they are maybe involved in illegal activity. The state responded to this motion, and this was filed. They certified it on September 24th. It wasn't on the docket until October 2nd, but the prosecution responded and said, yeah, we agree. Sure. Fine. Appoint them lawyers. Whatevs. So we now have another pretrial issue rolling. And in that pretrial issue, if witnesses are going to plead the Fifth and the prosecution isn't going to offer them immunity, like, hey, as to this thing, like a use immunity, not like a blanket immunity for everything you've ever done, but a use immunity for these transactions. If the state's not going to do that, then a person can plead the Fifth and be like, no. I imagine the reason some of these individuals don't have immunity is at least to one of them, they're already in custody. They might have already been prosecuted for the thing. So we'll see. But the court and the prosecution and the defense all agree that they should have lawyers. I imagine that the court's going to say fine and then set a date to do that outside the presence of the jury and before a jury is selected, because this can be sorted out beforehand. So that's the first in this series of motions from the beginning of October when we had that, well, a flurry of filings, if you will. So next we have two motions that go together. There's a request for an order compelling disclosure, and there is a new motion to reconsider bail. So we are going to take a look at both of those and then an affidavit, and then we're going to take a look at the fourth indictment in this case that has, well, it might be helpful for those of you that don't know this case to look at the fourth indictment first. Let's do that. Let's look at the fourth indictment first because it has statements of the facts and a pretty thorough and fulsome, if you will, statement of the facts. And then we will take a look at all of those because that might make more sense than looking at this afterwards, though this was filed the latest in time. I think that makes the most sense, especially for those of you that are newer to this case. 13-page indictment, fourth amended information. I mean, I keep calling it an indictment. It's an information because they didn't have a grand jury. We watched the preliminary hearing in this case. So, fourth time's the charm. This was filed on October. Oh, let me go look real quick. This was filed October 7th is when it hit the docket. The date on it is October 6th. This is from this week. And as of last night, I had not seen a response from the state with regard to the defense's other two motions, but I will check the docket before we wrap today and see if we have any new docketed items. We'll just do that together. So let's take a look at the prosecution's fourth amended information, shall we? We know what the charges are in this case. I'm not going to read them in full. Charge 1 is the aggravated murder, criminal homicide on or about March 3rd and 4th because it was in the overnight hour. The attempted murder, which is from February 14th, there's an accusation that Kouri Richins attempted to poison Eric Richins before, and then there is additional information on that. Count 3 is insurance fraud from January 29th. Count 4 is insurance fraud from June 14th. Count 5 is forgery from January 29th. So the forgery is relating to that insurance fraud claim in count 3. And those are the rest. Those are all of the charges. So some of the charges that were originally brought, the court removed from this information. And some of the charges, the prosecution willfully removed from this information and put them in the second case. So there is an entire fraud case secondary to this that was filed just a few months ago that has all of the mortgage fraud, all of the rest of the stuff. So let's take a look at their illumination of the facts. There's more information in here than there was in previous informations. And this gives a summary of what the prosecution says was shown through their information when they filed this information after the preliminary hearing. So the heading is that Eric Richins died from illicit fentanyl poisoning at 3:21 a.m. on March 4th. Defendant Kouri Richins called Summit County Dispatch and reported that her husband, Eric Richins, was, quote, not breathing, he's cold, he doesn't have a pulse. 10 minutes later, Summit County Emergency Medical Service personnel and sheriff's deputies arrived at the home. They performed life-saving measures, but ultimately declared Richins deceased. Victim Eric Richins deceased at 4:58 a.m. EMS personnel thought that, quote, he had been dead a while and noted that he was asystole the whole time. So, yes, they attempted to do life-saving intervention. No, that did not help. The pathologist at the Office of the Medical Examiner performed an autopsy on Richins and concluded that his immediate cause of death was, quote, drug intoxication, fentanyl, and determined that the level in his blood was 15 ng/mL, which is approximately 5 times a lethal dose, and that his gastric fluid contained an additional 20,000 nanograms of fentanyl. So that hadn't been digested yet. That's why they're highlighting it. They're highlighting that the amount in his system that had already been digested was 5 times a lethal dose, and yet there's more. So much. The OME determined that the byproducts of the fentanyl found in Eric Richins' gastric fluid were typical of illicit fentanyl, not medical grade fentanyl. The fact that they can determine that is wild to me. The OME determined that the fentanyl found in his body had been orally ingested. The OME also found 16,000 nanograms of quinapine in Eric Richins' gastric fluid. Quinapine is, quote, an atypical antipsychotic medication used for the treatment of schizophrenia, bipolar, and major depressive disorder. It's widely used as a sleep aid due to its sedating effect. I have a lot of thoughts about this. We might have time to get into them later. The defendant told law enforcement that at the time of Richins' death, she had a prescription for quinapine. So that was her description. That was her prescription. So, when we get, for those of you new to the case, when we get to what happened on Valentine's Day, I think there will be more illumination of why this amount and why the other prescription medication that makes you sleepy was included. I have thoughts. The night of Eric Richins' death, at 7:22 p.m. on March 3rd, the night of Eric Richins' death, the defendant's paramour, the boyfriend. Note of the paramour was not in the original informations. More information has come out about the lover as this case has progressed. At 7:22 p.m. on March 3rd, 2022, the night of Eric Richins' death, defendant's paramour text messaged the defendant a photograph of 2 people kissing that was captioned, "Love you." At 8:36 p.m., the defendant responded, "Love you," kissy emoji. I'm interested if they include the rest of the text messages, because there's a wait for Friday text. I know all of you are like, paramour would like to be excluded from this. I know. And boyfriend isn't quite right. You know, lover, I don't know. What else? How else do you put this in? What else do you say? While EMS personnel were attending to Eric Richins, defendant told law enforcement that she, all of you are saying side piece. I don't know if the lawyers would put in side piece. Maybe? Pew Pew Potato said man of the night. They're definitely going with paramour, but a lot of you had said affair partner. Fair. So defendant told law enforcement while EMS was still working on Eric Richins at the home that Eric Richins and she had a drink together at 9 o'clock to celebrate something at work tomorrow. A year later, defendant told law enforcement, "I made Moscow mules in the kitchen and then I brought them into our bedroom." Defendant further said that they drank the Moscow mules sitting on the bed. Sometime after Eric Richins' death, defendant wrote in a journal. This journal is still the subject to some motions to exclude about whether or not it was properly seized. So there is some question about whether the journal will come in. Also, yes, chat, it is not lost on me that our vocabulary has very clear words for when the woman is the affair partner and does not really have a correlating word for when it is a man. It's not lost on me, which is why they went, I think, with paramour. If it was a woman, they would have just said mistress. All right? Isn't that strange? I love you were like manstress. Some of you are saying the mister. I mean, the mister is just not quite right. Because it can be used in so many other words. Misty Wheeler said, I'm telling you the word is Sancho. Yeah, I mean, that's fair. Though I don't think they're putting it in a complaint in Utah. It's fair. So, some of you were saying the affair more. I love it. Look, it's just the OPP, right? We can go with Sancho. I'm here for it. But it's really just the OPP, right? Because OPP is equal opportunity. So, actually, if he's not dating someone, she would be the OPP. Either way, this is getting very confused. Aaron said in California, we would call him Sancho. I agree with you. But, again, I think it would take more time. But I appreciate all of you. You guys are the best. Defendants' statements were given to law enforcement. Let's talk about the journal because I side quested. The journal, defendant wrote in the journal, and we have been waiting to find out what's in the journal because we've heard about the journal. They've talked about the journal, and we have heard reference to the journal, but we have not gotten into what was in the fucking journal. Defendant wrote in the journal the night of Eric Richins' death that she and Eric Richins went to the kitchen and both started grabbing ingredients for a Moscow Mule and a lemon drop. We finished talking, made our way back to our bedroom, and brushed our teeth. No one's brushing their teeth immediately after drinking a lemon drop. Disgusting. Also, you're not drinking a lemon drop and then jumping into bed. What are we doing? Also, we know that Kouri likes to manifest, novel the way things happened. I think the journal was a plant, but we're not there yet. On the night of Eric Richins' death, the defendant told law enforcement, we eat THC gummies sometime. And yes, chat, this is the woman who was ranting in other letters that she was more holy than her sister-in-laws. Yes. Emily, THC gummies, that doesn't, no, whatever. It goes to the walk the dog letter. She told law enforcement that they eat THC gummies. Sometimes Eric will eat a gummy before he goes to bed. I mean, that's more realistic than having a lemon drop, brushing your teeth, and going to bed. The gummy is the relatable thing. However, what wasn't found in Eric Richins' system, chat? Right. If there was THC in his system, then it would have been reported. No THC in his system. THC lasts in your system. No THC in his system. No THC in his stomach. No THC. So this, Eric will take a gummy and then go to bed, isn't going to fly here. And in the walk the dog letter that I don't think we're going to get to today, but if you haven't watched my original coverage of the walk the dog letter, it's a whole journey that we go on together. But in the walk the dog letter, Kouri Richins is telling her mother, hey, we need to connect THC gummies to Mexico to say that the THC gummies were laced with fentanyl. I need you, mother, to tell brother, to tell lawyer. So Kouri in her walk the dog letter is saying, Mom, tell brother to go tell lawyer that that this is how this all happened. So, a year after Eric Richins' death, the defendant told law enforcement that she saw Eric take a THC gummy in the bedroom after drinking the Moscow Mule. The defendant then clarified, I didn't actually see him take it. He told me he took it, and then said he had to have taken it while I was making drinks. It would still be in his system though. In explaining to law enforcement how the defendant thinks the fentanyl got into Eric Richins' body, because of course you need an excuse, the defendant said, I honest to God think it was in one of those gummies. Not at that level, but whatever. 100%, she said. After the defendant's arrest for murder, the defendant's mother asked the defendant if she was sure the fentanyl came from a THC gummy. This is from jail calls. The defendant replied, that is what I'm banking on, yes. Those jail calls are gonna get you with the Google searches. Saul Portier already said, weren't you making drinks together? Uh-huh. Sure does. And just for a note, the OME did not find any THC in Eric Richins' blood or gastric fluid. The THC gummies in Eric Richins' home at the time of his death were tested and did not contain fentanyl. Uh-oh. You mean they did police work? They did police work? They tested the gummies that were found at the house? So weird. And none of those were tainted. Strange. They go on to say that the defendant told law enforcement that she went to bed with Eric in the bedroom approximately 9:30, 9:45 p.m. on March 3rd, 2022. There's no way in a half an hour you are mixing drinks, having drinks and chatting, brushing your teeth and getting in bed. But whatever. On March 3rd, 2022, and shortly thereafter, went to one of their children's bedrooms to sleep with the child because the child was having nightmares. The defendant said she awoke in the child's bedroom at approximately 3 a.m. on March 4th and returned to the bedroom. Defendant said she was asleep in the child's bedroom the entire time. Defendant told law enforcement that when she left the bedroom at approximately 9:30, 9:45 to go to the child's bedroom, she left her cell phone plugged in next to her bed and did not take it to the child's bedroom. But what's your phone gonna do, folks? What's your phone gonna do? It's gonna tell on you. It's gonna tell when it's plugged in. It's gonna tell when it's not plugged in. It's gonna tell when it moves rooms. It's going to tell when the screen goes on, when the screen goes off. It's going to tell on you if you're playing Midas Merge till 2 a.m. Emily, that sounds incredibly personal. I mean, it's just facts. Defendant told law enforcement that upon returning to the bedroom, she felt Eric Richins and he was cold to the touch and not breathing. Look, everyone's nightmare. That's a nightmare. However, she then said she immediately called 911. 911 received her call at 3:21 a.m. Forensic analysis of defendant's cell phone shows that it was unlocked 6 times between 3:06 a.m. and 3:21 a.m. when the defendant called 911. The analysis also shows that in the 13 minutes between 3:08 a.m. and 3:21 a.m., the defendant's phone or associated device traveled approximately 378 feet. You walking around the house? What are you doing? Defendant told law enforcement she performed CPR on Eric Richins pursuant to the 911 dispatcher's instruction. The 911 recording captures defendant counting as if she is performing chest compressions. EMS can tell if you have or if you hadn't. The defendant told her best friend, quote, speaking of best friends, asterisk, if you haven't watched the new criminal case against Kouri to see what she and the best friend what the history is there. Yeah. The defendant told her best friend, quote, I pumped so damn hard, so hard, screaming at him to come back to life. That's evanescence, ma'am. Also, I don't think the kids noted a disturbance. The defendant wrote in a journal that she, quote, began CPR compressions until the EMT arrived. They immediately took over. According to EMS, dispatch says she was doing CPR, but the first on scene fire guy said she wasn't. Valentine's Day 2022. A certain diner in Camas or Chamois or Camas or whatever, the diner, opens daily at 7 a.m. At 8:53 a.m. on February 14th, 2022, the defendant placed a 1-minute phone call to the diner. Defendant and Eric Richins' joint bank account statement shows a $41.29 purchase at the diner on this day. At 9:41 a.m., defendant texts Paramore, Sancho, quote, headed that way. At 9:49, defendant text messaged him a screenshot of a navigation application on her cell phone showing her current location on SR 32 and her projected arrival time at an unknown destination at 10:49. At 11:33 a.m., Eric Richins texted the defendant, I'm going to lay down for a bit. If I don't start getting better, I'm going to head to the hospital. 1 minute later, defendant responded, geez, it's that bad? Need me to come home? Go to take a nap and call me when you're up. 5 minutes later, 11:39, activity recorded on Eric Richins' phone and associated devices ceased. Activity did not resume until nearly 2 hours later at 1:32 p.m. At 1:43 p.m., Eric text messaged the defendant and asked, are you home? The defendant responded, no, in Provo, waiting for my cabinet installer. Ma'am, you were getting stuff installed into a totally different box. It wasn't cabinets. Don't play with us. Something was getting installed, but it wasn't cabinets. No, in Provo, waiting for my cabinet installer guy. Are you home? At 1:45 p.m., Eric Richins responded, I'm in the office. I've been sleeping out here. Eric Richins had a freestanding structure behind the home that was his office. Yeah, Anna G said wood, totally different kind of wood. Totally different kind of wood. At 1:59 p.m., Eric Richins called witness 1, a close friend, and reported, you almost lost me. Eric Richins told witness 1 that the defendant had left him a sandwich and a note in the front seat of his truck, and he went in the house with the sandwich, had one bite of the sandwich, and broke out into hives. Eric Richins said that he injected himself with his son's EpiPen that was on the counter, drank a bottle of Benadryl, and went to sleep. Eric Richins told witness 1 that he had almost died. Witness 1 could hear the fear in Eric Richins' voice and tell that Eric was scared. This is going to come into trial as a present sense impression from Eric Richins' to friend. At 2:11 p.m., Eric Richins called witness 2, another close friend, and reported, I think my wife tried to poison me. Valentine's Day, she leaves him a breakfast sandwich in his truck. He gets violently ill, tells his friends, I think she tried to poison me, and she's at the boyfriend's. She's at Sancho's. Eric Richins told witness 2 that the defendant had left him his favorite sandwich from the diner along with a note. He said that he ate some of the sandwich, got sick, and blacked out. He told witness 2 that he felt like he was going to die. Witness 2 was struck by the tone of Eric Richins' voice and said Eric Richins seemed a bit different, down, and somber. Yeah, that's fucking terrifying. And he was scared. Daniel asked what would cause him to break out into hives. We will talk about the hive reaction. I don't know if it's in here, but the hive reaction to fentanyl they have a expert to testify about that. Oh, it's in the next paragraph. Keep reading, Emily. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions to include hives. Eric Richins did not have any food allergies. So, on June 18th, 2022, 3.5 months after Eric Richins' death, the defendant text messaged her best friend about the incident. The defendant wrote, "It was Valentine's Day, and Eric and I were both working from home that day, and I ordered lunch from the name of the diner, 8,000 exclamation points. He never broke out in hives or used an EpiPen. I was fucking with him. He said the sandwich hurt his stomach, so he was going to take a nap. No hives, no EpiPen, exclamation point." On August 22nd, 2023, nearly 4 months after the defendant was arrested for the murder of Eric Richins, the defendant discussed this incident in 2 phone calls. In a phone call with her mother, the defendant confirmed that she was the person who picked up the sandwiches from the diner on Valentine's Day. She said, "We ate in the office." In a phone call with her brother, the defendant discussed buying lunch at the diner that day. And they also have all the receipts, and they also have her phone going to the diner. This next part is going to be part of the motions that we're going to cover today. Defendant purchased illicit fentanyl shortly before Eric Richins' near death on Valentine's Day 2022 and death on March 3rd and 4th, 2022. The defendant occasionally employed witness 3 to assist her with renovating houses. On January 20th, 2022, defendant text message witness 3, quote, I did want to chat with you about something super random, exclamation point. Not now at kid stuff, exclamation point. I'll call you tomorrow if that works. So she text messaged somebody, I want to talk to you, but not now. Bitch, just text me when you want to talk to me then. On January 21st, 2022 at 7:24 p.m., the defendant text message witness 3, hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd at 11:06 a.m., the defendant text message witness 3, got a sec? Witness 3 told law enforcement that he spoke with the defendant on January 22nd, 2022, and the defendant asked him for fentanyl. The defendant told witness 3 she wanted fentanyl, quote, for a client who had back pain. Ma'am, you're a realtor that flips houses. What other services are you telling people you're providing? Witness 3 told the defendant that he would not get her fentanyl. The defendant hung up on witness 3. On January 22nd, 2022 at 5:35 p.m., after the phone call in which witness 3 declined to acquiesce to defendant's request, the defendant text messaged witness 3, have another one for you. Call me if you get a sec. Witness 3 told law enforcement that during the second phone call with the defendant asked him for propofol. Witness 3 told the defendant he could not get her propofol. The text messages from January 22nd, 2022 between defendant and witness 3 were manually deleted from the defendant's phone. They got them from the other person's phone. Right. Manually deleted from Kouri's phone. After that date, the defendant and witness 3 did not communicate ever again. The defendant and witness 3 had communicated regularly throughout the prior year. On May 31st, 2022, approximately 3 weeks after defendant's arrest for the murder of Eric Richins, the defendant's mother text messaged the defendant, quote, witness 3 name, running his mouth. Running his mouth and his phone. Yeah. 100%. The defendant occasionally employed witness 4 to clean houses. Witness 4 told law enforcement that sometime in early 2022, before Eric's death, the defendant either called or texted and asked her to procure some fentanyl for defendant. Forensic analysis of Verizon records for defendant's cell phone shows 746 SMS text messages, 94 MMS messages, and 12 calls between defendant's phone and witness 4's phone between January 1, 2022 and March 15, 2022. These messages were manually deleted from defendant's phone. The defendant's phone contained messages to and from witness 4 before and after this time frame. You know, to forensic examiners, a big glaring gap is just as telling. Weird that there's like a black hole between January and March. So strange. Witness 4 told law enforcement that pursuant to defendant's request, she contacted witness 5 for an introduction to someone that would sell her fentanyl. Witness 5 confirmed that witness 4 asked her for the introduction to someone that would sell. Witness 5 elaborated that witness 4 messaged her through Facebook asking to speak with her and called witness 4 shortly thereafter. Facebook message from witness 4 to witness 5 on February 5th, 2022 at 1:37 asked, "Text me, I got a question, won't do it on this." I mean, yeah. Don't message it on Facebook Messenger. Sure. In response to witness 4's inquiry, witness 5 provided witness 4 with the phone number of a dealer, witness 6. This is going to come up as we continue on into these filings. Witness 4's phone contains a contact for witness 6 with their phone number. The contact is labeled in a fashion that connects witness 5 with witness 6. Like, name, friend of name, or name's guy name, whatever it is. Witness 4 told law enforcement she contacted witness 6 shortly after receiving the contact information from witness 5 and asked to make the purchase. Witness 4's phone records established she texted witness 6 on February 10th at 8:52 p.m. Witness 4 told law enforcement that she met witness 6 at the Maverick gas station in Draper on February 11th and purchased from him 15 to 30 round light green blue pills, which she understood to be fentanyl. Witness 4's phone data shows that she called witness 6 several times on February 11th between 5:19 and 6:52 p.m. Witness 4 stated that these calls were to coordinate the specific time of the purchase. Witness 4's phone data also shows that she text messaged witness 6 several times beginning at 7:18 p.m. while she was located at the Maverick. Witness 4's phone data shows several text messages between defendant and witness. On February 11th, the messages begin at 3:42 p.m. while witness 4 was at her home and continued at 6:23 p.m. when she passed through Linden on her way to the Maverick gas station in Draper. The defendant and witness 4 text messaged at 7:18 when witness 4 was located at the Maverick and text messaged with witness 6. The messages continued at 8:20 p.m. as witness 4 passed through Lehigh on her way back to her home and concluded at 8:56 p.m. when witness 4 was at home. Witness 4 told law enforcement that she delivered the pills that she purchased from witness 6 to the defendant in a hand-to-hand transaction in the driveway of her home on February 11th or February 12th. Witness 4's phone data shows that in the addition to the text between the defendant and her that were exchanged on February 11th, the defendant and the witness exchanged text messages on the 12th at 9:58 a.m. and 2:49 p.m. Witness 4 was located at her home during the exchanges. The defendant and witness 4 exchanged 30 text messages on Valentine's Day 2022. Remember, Valentine's Day is when Eric took a bite of the breakfast sandwich and broke out into hives. Witness 4 told law enforcement that in late February, the defendant told her that the fentanyl pills she previously provided were not strong enough and asked that she procure some stronger fentanyl. Valentine's Day, sandwich, gets sick, tells his friends he thinks he almost died. And then after Valentine's Day, the defendant says that they weren't strong enough. She's literally like, just lay down and sleep. It's fine. Just take a nappy nap. And then is reaching out to her contact saying that the pills provided were not strong enough and asked that she procure something stronger. So this is the second purchase. Witness 4 stated that the defendant specifically asked her for, quote, some of the Michael Jackson stuff. During the second request for fentanyl, by the way, Michael Jackson died of a propofol overdose under the care of an anesthesiologist. And this is my speculation. I don't speculate in cases a lot, but this is my speculation, right? Here it is. And we've watched the prelim in this case. I'm going into this case with a lot of information. I don't go into every case with a lot of information. This one we're going into with a lot of information. I think Kouri Richins saw all the news about people dying from fentanyl overdoses, from it being in a car or them touching a package with it, and was just like, oh, so if you're near this stuff, people die. Okay, that'll work. And then when it didn't work, she was like, well, what the fuck? Fake news. He didn't die. I need either something stronger or I need the stuff that killed Michael Jackson that is used in a hospital anesthesiology setting, unless you're Michael Jackson. But that doctor was prosecuted. I really think it's a what? But everybody just dies. Like, the news says everybody just dies. Like, that's my speculation. We'll see. Don't learn to crime on television. You know. But that message, I need some stronger stuff, isn't going to go well at trial. So she asked for, quote, some of the Michael Jackson stuff and conceded that the defendant may have referred to Michael Jackson during the earlier request. It's like at some point she said it. I don't know when. On February 26, 2022, Witness 4 sent Witness 5 a Facebook message asking that witness provide her with Witness 6's phone number again. Look, they deleted the contact. They did the hand-to-hand transaction, deleted the contract. Smart. But then you have to Facebook message again. Witness 4 contacted Witness 6 again to arrange an additional purchase at the same Maverick gas station. Witness 4's phone data shows that on February 26th, beginning at 2:25 p.m., the defendant and Witness 4 exchanged several text messages, continued to exchange them throughout the evening. Witness 4 left her home and went to the Maverick gas station in Draper, and then back home. Witness 4's phone data also shows that she exchanged text messages with the defendant and Witness 6 while she was at the Maverick. On May 8th, 2023, defendant was arrested for the murder of Eric Richins, received a copy of the charging document, probable cause statement. The probable cause statement referred to Witness 4 by her initials and contained many of the facts presented above. On a jail call that day with her mother and brother, defendant said, Eric asked me to ask Witness 4 for the pain pills. Internet searches on defendant's phone. The defendant uses several cell phones, including burners. The cell phones that the defendant primarily used leading up to and shortly after Richins' death, Eric's death, indicates that a significant amount of information was manually deleted from it, particularly between January and mid-March of 2022. Forensic analysis of one of defendant's cell phones shows that by April 16th, 2022, 3 days after law enforcement first informed the defendant that Eric Richins died of a fentanyl overdose, the defendant's cell phone was used to access website articles with the following titles, among others. So these are articles, not Google searches. We'll get there. Utah State Prison Timpango's women's facility. What happens to deleted messages? Cause of death usually not impact life insurance payment, or cause of death does not impact life insurance payment. How do police and forensic analysts recover deleted data from phones and signs of being under federal investigation? Forensic analysis of the same phone also shows that by June 6, 2022, the defendant's phone was used to conduct the following internet searches, among others. Quote, can you delete everything off an old iPhone without actually having it, I think. Quote, women Utah prison. Quote, can cops uncover deleted messages iPhone? Quote, can cops force you to do a lie detector test? Quote, if someone is poisoned, what does it go down on death certificate as? Quote, how long? It doesn't say how's chat. She actually typed HOW. How long does life insurance companies take to pay? And quote, what is a lethal dose of fentanyl? Including the periods that happen so often in iPhone searches instead of hitting the space button. Why they didn't include the Google search for luxury prisons for rich people, I don't know. It's included in others. It's not included in this one. The defendant was in financial distress. The next part of this, we don't need a ton for today, but it goes through the fact that the defendant was completely financially underwater, that it was getting worse, and that Eric Richins' company was doing well. So we're gonna skip past that, but her financial state was not good. We'll link down below where I cover the financial crime case. It's wild. Defendant had an interest in Eric Richins' successful business only if he died while they were married. This goes to what law enforcement is arguing Kouri Richins' understanding of the prenup is. Kouri Richins is arguing that a bit. Eric Richins and his business partner owned a stonemasonry business called C&E Stonemasonry. They founded the business December 1st, 2009, more than 3 years prior to Eric Richins' marriage to the defendant. In 2020, C&E's adjustable taxable income was over $1.4 million. Eric and defendant entered into a premarital agreement, sometimes referred to in this as the PMA, dated June 15th, 2013. That is subject to a secondary litigation at the moment. The PMA further provides that the defendant, quote, shall have no right or claim to the business except that if Eric Richins dies prior to defendant while the two are lawfully married, Eric Richins' partnership interest in the business shall transfer to the defendant. So if they are married and he passes away, then she gets his 50% of the successful business. As early as February 2019, defendant told witness 7, a friend, that she was, quote, trapped in her marriage and that the PMA would, quote, leave her without anything financially, and that she, quote, didn't know a way out of her marriage. On December 17th, 2021, the defendant told witness 8 that she felt stuck and trapped in her marriage and it would be better if Eric Richins just died. They didn't include the Paramore text where she says, just wait. Defendant mistakenly believed she would inherit Eric Richins' estate. On October 13th, 2020, Eric consulted an estate planning attorney. Eric informed his lawyer that he wanted to protect himself in the short term from recently discovered and ongoing abuse and misuse of his finances by the defendant, and to protect his 3 children in the long term by ensuring that the defendant would never be in a position to manage his property after his death. There was a lot of financial fuckery happening that it seemed Eric was unaware of, and when he discovered it, he went to a lawyer. On November 3rd, 2020, Eric Richins executed several estate planning instruments, including a healthcare directive, durable power of attorney, pour-over will, and a living trust. In each of these instruments, he appointed his sister, Kouri Richins, as his agent, fiduciary, and trustee. This is the lawsuits going on over the estate with the sister-in-law, Katie, who became the executor of all of these documents that Eric was moving things to so that Kouri couldn't get her hands on the money and to protect his kids. He transferred his home. It was his home that he bought before the marriage. He transferred his home and interest to C&E to the trust. Richins, Eric, removed the defendant as a beneficiary of his $500,000 New York life insurance policy, and designated the trust as the beneficiary. On March 6th, in the immediate aftermath of Eric Richins' death, Eric's sister, Amy Richins, was at Eric Richins' home. The defendant, Kouri, asked Amy to leave the property. We saw this talked about in the original bail hearing, because at the original bail hearing, we heard about Kouri and the sister getting into a physical fight. Let's see how much of that they detail here. Kouri asked Amy to leave the property. Amy responded that the home didn't belong to Kouri and belonged to the trust. Leave. This isn't your home. You leave. This is going to have to come up in trial because in the body cam that came up during one of the hearings, Kouri keeps asking the cop, is this my sister-in-law? Is my sister-in-law trying to take the house? Like, she was, when they were searching the home and keeping Kouri out of the home, she kept asking if it was her sister-in-law. Like, is this my sister-in-law? So the jury's going to need to understand why that happened. Defendant asked Amy to leave the property. Amy responded, this shit doesn't belong to you. I'm sorry, I'm embellishing. That the home did not belong to defendant and instead belonged to the trust. This is 3 days after, for Amy, 3 days after her brother died unexpectedly and shockingly. The defendant then struck Amy Richins several times. Not really a fight, an attack. Kouri wilded out and attacked her sister-in-law. The defendant, in a text message to her paramour, recounted the event. Quote, I lost it on Eric's sister. I lost it on Eric's sister finally and punched her a couple of times. Angry face emoji. My brother ripped me off of her before it got too intense. She called the cops. It was at my own house because I told her to leave and she wouldn't. She said this is her brother's and she didn't have to. So I said, get out or I'll get you out. Okay. Sheriff's deputies responded to the home, called the estate planning lawyer from the scene. The cops called the lawyer. Whose house is this? Can you help? The lawyer explained to the defendant, this is when she learned the first time. This is when she learned. 3 days after Eric Richins passes, his sister's at the house, gets throat punched by Kouri. Cops show up. Cops call the lawyer, put the lawyer on what? Speakerphone? And then inform her for the first time with the sheriffs looking at her face with their eyeballs. The defendant explained to the defendant, the lawyers explained to the defendant that Eric had placed the home into a trust and that Katie is the trustee. The defendant's behavior during their conversation led the lawyer to believe that the defendant was learning of the trust and its provisions for the first time. The defendant later told law enforcement that she was, quote, just now learning after all of this happened about the trust in general. Kouri didn't know. Kouri didn't know. Kouri didn't know. All of you are saying, I hope there's body cam. I hope there's body cam too. Kouri didn't know. Kouri didn't know. So she attacks the trustee, Eric Richins' sister. And then the cops show up and call the lawyer. And the lawyer is like, yeah, that's not yours. And then the trust doesn't kick Kouri out of the home. This is my supposition. Doesn't kick her out of the home because I think they want the kids to be able to stay in the home after their father passed away. And at this point, the cause of death is unknown. The autopsy's not back. They don't know. So nobody knows all of this on the day that they're standing there. But the sisters have to know something is up because he put everything into a trust. So it seemed to me by the timing of some of this that perhaps Eric was getting ready to try to fight. However, if Eric had left and taken the kids, it would have gone really badly in Utah family court. I think Eric was in a really tough spot. He was trying to protect the assets from financial abuse, but if he had left and just taken the kids, Utah courts would have just excoriated him. And the fight for custody would have been difficult. I feel for Eric. And I don't know, if you think your spouse is trying to poison you, you don't leave your kids there without you. Like, the whole thing makes me so incredibly sad, and he's stuck trying to figure out what to do. So, defendant was a beneficiary on a significant amount of life insurance. Right after the death, she starts putting in the life insurance claims. There's a aggregate death benefit of $1.3 million. She was applying for all of that. Defendant submitted falsified bank statements to get the loans. We talked about this. This isn't going to come up in the motions today, but she was cutting and pasting his business bank statements with her business on them. So the body of his statement, but then the information of her bank statements to get mortgage loans. That's lined out more in the fraud case that we have covered. Defendant fraudulently claimed insurance benefits from Eric's death. Defendant was the beneficiary of 2 insurance policies on Eric's life insurance with the aggregate. This is an additional aggregate death benefit of $350,000. One of the policies issued on May 12, 2017, the other February 4th, 2022, 1 month prior to his death. Taking out more life insurance, are we? Weird. On April 28, 2022, defendant submitted a claim against the policies. On June 7th, TruStage learned that the cause of death, so not until June are they starting to learn about the cause of death. On June 7th, TruStage learned that the cause of death was drug intoxication fentanyl. On June 14th, TruStage left a voicemail with Kouri requesting a copy of the prescription for the fentanyl. Later the same day, defendant informed TruStage that the fentanyl was not prescribed and that she didn't have any idea how he obtained it. The next day, on June 15th, the defendant reiterated to TruStage that she really did not know where Eric obtained it. That is the end of the updated information that they're going to go to trial on. It provides, a cleaned up version because some of the counts got moved into the fraud case. Some of the counts have been removed since the original filing. They had 2 distribution counts that were just, I don't know why they charged those. It was odd to me. So this cleaned up information gives us more indication of what was in the journal that is still being fought over. the journal, there were multiple journals, but there is still a journal that's being fought over that is not going to pretrial motions yet. When we start getting to the streams of pretrial motions, we will cover them and hear the arguments over the journals and whether or not they were properly seized and whether any of those journals are going to be kept out of trial. So now that we have gone through kind of the new factual information that we have learned and the cleaned up fourth amended information, let's take a look at what the defense says the prosecution has withheld from them. The prosecution has not responded yet that I have seen. I'm going to look real quick at the docket before we pull this one up, and then I'll probably look again at the end of... Why did y'all change your entire website between yesterday and today? I just want to log in. Hold on. Let's log in from the other browser. That'll be easier. Maybe. Maybe it'll be easier. But as I'm saying, freaking captchas. As I'm saying, the prosecution hasn't responded. I just want to make sure that they didn't respond literally this morning. So we're going to double check the docket. And if there is anything, we'll double check again before we're done because West Coast, but let's just check real quick. Didn't see anything before stream, didn't see anything as of last night, but you never know because a lot of things got filed yesterday. So as that docket pulls up, we will be pulling up the next motion for the defense because it's still not up yet. Wrong one. Emily, wait, this one. This was filed just last week. This is the defense request for an order compelling disclosure of exculpatory evidence. So we are going to go through what the defense is arguing, what they are asking the court to compel, and what they are asking the court to turn over. Now let's get, this docket is over 1,000 docketed items. So it's going to take me a second to scroll because it also won't just jump to the bottom, which is fairly annoying. Let's see. We have nothing new. Boo. We have a sealed motion for defense funding. All right, we'll check again before the end of stream, but as of 1 o'clock on Wednesday, October 8th, Central Time, the prosecution has not responded to these motions yet. When they do, we're going through it. For sure. Prosecutors, quote, prosecutors say she mixed a lethal dose of fentanyl into his drink, footnote 1, from the New York Times. Kouri Richins' housekeeper allegedly sold her fentanyl pills prior to husband's poisoning. Footnote 2, link to YouTube video. Kouri Richins, the Utah mom who allegedly poisoned her husband with fentanyl-laced cocktail. Footnote 3, CBS. Prosecutors allege she gave Eric Richins a lethal dose of fentanyl on the night of his death. Eric's family suspects she placed the fentanyl in a Moscow Mule. Footnote 4, CBS. Investigators now say a woman accused of fatally poisoning her husband had asked multiple people if they could procure fentanyl for her. Footnote 5, KSL local media, their coverage of the case has been great. Prosecutors previously have said she acquired fentanyl, and every time they say fentanyl, it is italicized, through a woman who cleaned house for her businesses, both in the months before and shortly after her husband's death in March 2022. A search warrant granted earlier this month, however, indicates investigators believe the woman was not the only person Richins went to for fentanyl. Yeah, she went to the dude who stopped talking to her, too. Alleged to have. The defense then says all those headlines stem from allegations that Mitch Richins procured oxycodone, and ultimately fentanyl from her relationships and connections with, well, they're just putting everybody's names out here now. CL is the go-between who did the hand-to-hand transaction, was finding everybody else. That's who CL is. Robert Crozier, Nick Bonsavage, and Susan Kohler. Initially, Miss Luber, CL, informed investigators that fentanyl was never procured. See transcript of the interview, April 27th, 2023. The investigating officers subsequently interviewed her on May 3rd, 2023. It was in that meeting that she indicated she got fentanyl from Robert Crozier. That is alleged to be the individual that was at the Maverick gas station giving the narcotics to CL, who took them back to Kouri. Haunted Shadows are the names supposed to be redacted. The prosecution has always referred to people by witness number. The defense, not so much. So it is at this point what it is, but they're going to be on a witness list, and the witness lists are publicly filed, and they're going to be witnesses at trial. So the shit's kind of out of the horse at this point. But there was not a protective order. The prosecution had just chosen to do that. The investigating officers subsequently interviewed CL on May 3rd, and it was then that she said that she got the fentanyl from Robbie. That's at the hand-to-hand, the Maverick gas station. Robbie was interviewed in May 2023. During his interview, he confirmed that he had sold fentanyl to CL on 2 occasions. Remember, there is the before Valentine's Day, and then there is the after Valentine's Day. Before Valentine's Day, the egg sandwich made Eric Richins incredibly sick. After Valentine's Day in March, it was alleged to be a Moscow Mule, and that is when he was deceased and had a significant amount of fentanyl in his system. Sometime in April of this year, Crozier was interviewed by 2 members of Summit County prosecution team at Starbucks in Salt Lake City. That's so odd to me, to not just have somebody come into the office. The prosecution team asked if he had sold fentanyl to Ms. Luber. He said he had not sold fentanyl. He specified that he had sold OxyContin to Ms. Luber on 2 occasions in early 2022. He told the prosecution team that he met with CL at the Maverick in Draper, both times to sell her pills. The prosecution team asked why she had stated that he had sold fentanyl. He specified that he did not remember saying that he had sold fentanyl, and told them he had been detoxing during that interview and was quote unquote out of it. He told the prosecution team that he was certain he had sold her OxyContin 30 milligram pills, also known as Roxy's. Have we heard enough about Roxy's and Oxys to last us the rest of our life? Probably. But anyway, that's where we're at. The prosecution team asked him several times if he was sure, and he told them he was sure it was OxyContin. The prosecution has been aware of this exculpatory evidence since April of this year. The prosecution did not inform the defense of this information. I'm very curious. I'm very curious how the prosecution is going to respond to this. I'm also curious if they're going to argue, well, it's not exculpatory, that he said he was out of it. He said it was fentanyl. Then he said it was Oxy, and Oxy, I mean, it was ultimately fentanyl in his system. So whatever he thought he was selling, it was ultimately fentanyl in Eric's system on the 3rd. Could oxycodone cause that type of reaction with the breaking out in hives from Valentine's Day? They said it can in their information. So I don't know if it's exculpatory or not, but what he thinks he's selling and what people are getting is a huge issue. However, any change of witness statement has to be turned over. So the change of statement has to be turned over. I'm curious what they say about that because it has to be turned over. So they are saying that the prosecution has known this since what? April this year? No. So since April 2025, if a witness changes their statement, that has to be turned over. They say that the prosecution knew this since April of this year and did not inform the defense. That's a problem. What's the solution to that problem? Well, they haven't gone to trial yet. The solution is normally, well, you have the information now, and you can ask the witness about it. But they are then complaining that there's no press release issued, no reports, nothing. The prosecution just kept quiet. They needed to turn it over to the defense. In preparation for trial, defense counsel located and interviewed the witness within the past 30 days. Well, yeah, he's on the witness list. It was during this interview that the meeting and the exculpatory information became known to defense counsel. They're calling the difference between whether he sold fentanyl or whether he sold oxy to be the exculpatory thing. We can argue over and over about whether or not that's exculpatory. It doesn't matter. It needs to be turned over. A change in witness statement has to be turned over. Given the fact scenario that we were just talking about and the fact that on the street, these things can be incredibly intermingled, if not called one thing and actually another thing, is for discussion. But footnote, they go on to say it was during this interview that the meeting with the prosecution became known to defense counsel. Footnote 6. Footnote 6. Defense looked within the discovery folder provided by the prosecution after the discovery of this information and prior to the filing of this request and could not find anything related to this interview. That is a problem. That is a problem for me. The argument about whether or not this is exculpatory is one thing, but not turning it over is a problem. That's absolutely a problem. I'm very curious to see what the prosecution has to say. They go on to say the prosecution is required to disclose to the defendant the following material or information directly related to the case of which the prosecution team has knowledge and control. Evidence that must be disclosed under the constitutions of the U.S. and Utah, including all evidence favorable to the defense that is material to guilt or punishment. Even if it's not, a change in witness statement still has to be turned over. Agreed. Their duty to disclose is a continuing duty as the material or information becomes known to the prosecutor. 100% agree. Ongoing duty. They go on to say Rule 3.8 of the Utah Rules of Professional Conduct prescribe duties specific to the unique role of the prosecutor. It requires a prosecutor in a criminal case to, quote, make timely disclosure to the defense of all evidence or information known to the prosecution that tends to negate the guilt of the accused or mitigates the offense. It's still a witness change of statement. He thinks he's selling oxycodone and not fentanyl is not earth-shattering to me, but I want to see what his affidavit says. But him saying, I don't remember saying I sold fentanyl, I was out of it during my interview, is something that the defense needs to be made aware of, I think. They go on to say the timeliness of the prosecutor's disclosure of exculpatory evidence is a matter governed in Utah by our rules of criminal procedure. The prosecutor must make all disclosures as soon as practicable following the filing of charges and before the defendant is required to plead. Yeah, I think the change of statement should have been turned over. Let's see. It's aimed at allowing the defendant to adequately prepare their defense. Yes. I agree they need to be turned over. The defense goes on to say the distinction is critical because without its ethical counterpart, a prosecutor would rarely face a consequence because it could hide behind a wide latitude and continuing obligation. And we've seen that in Massachusetts, right? In Massachusetts, we have seen the prosecution hide behind continuing obligation. And when I have been like, why the fuck wasn't this turned over? We've seen the prosecutors go in court and being like, it's an ongoing obligation. We'll turn it over when we get it. Ew. It goes on to say in the rules, quote, if the prosecutor's possession of exculpatory evidence is uncovered at trial, this is well before trial, at trial, a subsequent admission of the fact may be somewhat mitigated at a sanction phase, but the admission is not itself a fulfillment of the Rule 3.8D duty of disclosure. We are pre-trial. It needs to be disclosed. They are saying that a prosecutor can't conflate the Brady standard with the prosecutor's ethical duty. The two standards are distinct. The question under Brady is a matter of due process and whether the prosecution's failure to disclose exculpatory material so undermines our confidence in the verdict that we should order a new trial. Not the case here. But Rule 3.8 is different. And I think that's why they're focusing on it, because Rule 3.8 is the obligation, not what happens with in-trial disclosure of Brady evidence, CEG Baldwin. They're saying that the ethical rule is aimed at a fair trial by articulating a standard for a motion for a new one, but also at establishing an ethical duty that will avoid the problem in the first place. In stating that duty, our rule requires timely disclosure by the prosecution. That duty cannot be fulfilled by a prosecutor's mere admission of the existence of exculpatory evidence made after the witness first uncovers it. Footnote 14, citing the rule and case law. In addition to the timeliness of disclosure, the prosecutor's state of mind relating to the disclosure is paramount in determining an appropriate sanction. I imagine the prosecution here is going to say it's not exculpatory. That's going to be their argument. I think a change of statement should be turned over, but they're going to say it's not exculpatory. So they say, they defense, here the prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, I think that's a real strong statement. I think that's a real strong statement. Here, the prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. The prosecution's failure to disclose and continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl inflicts ongoing harm on Ms. Richins, the public, and the integrity of our legal system. They are banging the podium with this and doing their job. But Ms. Richins intended to procure fentanyl. Eric Richins, at his autopsy, in his system, had fentanyl. So if a witness comes in now and says, I originally said I sold fentanyl, but I was selling oxycodone, the jury's going to be like, are you distancing yourself? Or B, did you think it was oxycodone and it was so laced with fentanyl that fentanyl's all that showed up in his system? Or is it something else? And I would need to look at the law in Utah to see if dealers can also be charged, like the person who provides the thing can also be charged. Because that also might be part of the problem here, is that the witness is like, Oh yeah, no, no. If I provided it and it killed someone, I don't want to be responsible for that. Now, the Kouri Richins intervening intent might change that. This does not seem to be an accidental OD situation, which she will argue. But I don't think this eviscerates the prosecution's theory. So I just don't see how. Well, let's look more at the change of statement. I also want to hear what the prosecution has to say, because I just don't see how this is the thing. Because the conversations between Kouri and CL, the go-between, really goes to what Kouri is intending. And then the go-between reaches out to a guy and says, can you sell me this? And the guy's like, here's what I'm selling you. No one else was in the house except for the children. And sadly, the thing that's really common with overdose cases is that the thing that the person is overdosed on is generally in the vicinity of the person. That's not the case here. So I think it is a very stretchy reach about whether this is the linchpin that unravels the entire Kouri Richins case. I'm not persuaded by the hyperbole. I understand their argument. I'm interested to see, because at best, what I'm seeing is a witness who is changing their statement that should be turned over. And it's now clear to the defense. We are months ahead of trial. So whether or not the court chooses to sanction the prosecution for failing to disclose it becomes really the main question. So they say the prosecution's failure to disclose and continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl inflicts ongoing harm to Ms. Richins, the public, the integrity of the legal system. They say this is precisely the type of misconduct Rule 3.8 was designed to prevent. By withholding this evidence, the prosecution abandons its duty to seek justice and undermines the assurance of a fair trial. But you interviewed the witness, because the witness is on the witness list. So you interviewed the witness. The defense goes on to say, no doubt there will be an attempt to chalk this up to an oversight, perhaps as an oversight that should be excused as nothing more than careless. But this was not an oversight. This was a continued and knowing concealment. It is not a blemish on the fruit. We're doing a lot. It is rot at the core, poisoning the whole harvest of justice. Too much. Too much. Too much. Too much. You're just banging the podium. They then quote Thomas Hobbes from Leviathan, "Covenants without the sword are but words." Courts have long trusted the prosecution to discharge its duty without supervision, but when the trust is broken, when evidence negating guilt is withheld, trust alone no longer suffices. In this case, words like timely and becomes known suddenly demand a deadline. Okay. Counsel moves this court for a standing order imposing a 3-day deadline on the prosecution to disclose the following to the defense. The court has not, by the way, issued an order on this at all. I agree with you. Kate, AKA Track a Cat, said in the chat, the word poisoning. Oh, it was a choice. It was a choice. But I think the strength of the language and the strength of their argument are not matching for me, but maybe I'm not appreciating the gravity of the situation. We're going to read the rest of their motions, and there is an affidavit from this witness. Maybe it's more. But right now what I'm seeing is a changed witness statement that should be disclosed and was discovered during a witness interview because that witness is disclosed. All right. They are asking the court for a 3-day deadline. All evidence, including emails, text messages, phone messages, recording, video footage, and any other form of correspondence involving the prosecution teams or any law enforcement official and the witness. Okay, fair. Any conversation you had with the witness, fine. That should be turned over anyway. Unless it's literally, you're going to need to be at the courthouse on this day. Are you available? But a change in statement needs to be disclosed. They say including correspondence about setting up a meeting and any sort of summaries of the meeting. Yeah, summaries of the meeting should be turned over. All notes, correspondence, reports prepared by law enforcement officials or any member of the prosecution team discussing the interview in April. Conversations between the attorneys is going to be work product. Same with law enforcement. A summary of the meeting is probably appropriate. Any statements, recordings, reports, or notes in whatever medium, including emails and texts, that tend to negate guilt. I mean, I think their argument of what negates guilt and the prosecution's view of what negates guilt are going to be different. Furthermore, the defense respectfully requests the court require the prosecution to disclose on the record or reduce to writing and provide to the defense all oral statements discovered when interviewing witnesses that tend to negate guilt or contradict prior statements by witnesses. Yes, that should happen. Also, that's the acknowledgement about the contradictory statement. Yeah, contradictory statements should be turned over. 100%. Footnote 16. Including those witnesses interviewed in preparation for the last trial setting. Sure. Agreed. They should turn those things over. I don't know if the way the defense has described this is exculpatory in the context of the case. It is clearly a changed witness statement, which should be turned over. How big of a deal that is going to depend on more information and circumstances. But the defense wants Kouri to be released from custody. She has been in custody since her arrest on May 8th, 2023. So let's take a look. Am I right on that date? That feels awfully long. She was arrested 2023, right? Yeah, May 8th, 2023. God, it's been a long time. This case was supposed to go to trial and then wasn't supposed to. It's just, blah. So long. Let's go look at the motion for bail. They have tried to get Kouri Richins out of custody multiple times. I do not know. Well, we'll see what they argue. This does not seem like a change of circumstance to me that would even warrant a bail hearing, but let's see what their arguments are. I'm skeptical to start because we've seen quite a lot of hyperbole from the defense. But the this is exculpatory is not enough to let somebody out of custody because this doesn't delay the trial. They've interviewed the witness. So I understand why they want Kouri out of custody. I understand why Kouri wants to be out of custody. I don't think that's going to happen. In the 3rd Judicial District Court, this is the defense motion to reconsider bail and conditions of release. Well, we will see, won't we? Kouri Richins, by and through undersigned counsel, moves the court to reconsider setting bail and ordering conditions of release. pursuant to section 77-20-207-1AB of the Utah Code, which provides in part that a party may move to modify a pretrial status order at any time upon a showing that there has been a material change in circumstances. Counsel, what is the material change in circumstances? They're going to argue, I imagine, based on the last motion, these were filed at the same time, that the witness's statement materially changes the circumstance, because they are trying to argue that that means Kouri didn't procure fentanyl. Okay. History of proceedings. The matter of bail has been brought before. I'm glad that they did this, because it's been a long time. It's been a while. History of proceedings. The matter of bail has been brought before this court on 2 occasions. First, on June 12th, 2023, this court conducted a detention hearing and considered exhibits, testimony, and argument. We watched it. At that time, Richins was facing a potential death penalty on aggravated murder charge and was not entitled to bail as a matter of right under the code. The court did, however, go on to find that there was substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community if released on bail. At the time, the court made no findings of risk of flight. On October 22nd, 2024, Richins, through counsel, filed a motion to reconsider bail, arguing that there had been a material change of circumstances since the prior detention hearing. The court found that a material change in circumstance did exist, and on November 12th, 2024, a hearing was held on the motion. After oral argument, the court ruled from the bench that there was still substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community and further was a flight risk. Ms. Richins has now been held in pretrial custody for 28 months. Y'all are the ones who had the case stayed to appeal things. Also, they are saying the change in circumstance is the witness statement. My question and concern in this is that A, it's not exculpatory. B, it doesn't change what Kouri was doing. None of this changes what Kouri was doing. No, he said he gave her this versus that. Kouri was still asking people for the thing. Even if that witness didn't testify, you still have the middle witness, CL, who said, Kouri asked me for this. I asked a guy for a guy. I found the other guy. I met him at a gas station. I said, give me this. He gave me things. I gave them to Kouri. None of that changes. Like none of, he doesn't say he wasn't there. He didn't sell anything. He said, no, I don't think I said it was fentanyl. I think it was oxy. I don't think this is a material change of circumstance. And I don't even think they need to bring it at trial because of what she was texting and asking for. I think that's more relevant. And the autopsy findings. Material change in circumstances, I'm curious to hear how they articulate this. They're doing their job. They're doing their job. They're doing their job. And a jury might be like, yeah, we don't believe that dude. One way or the other. Material change in circumstance since November of 2024. The following circumstances have material changed since the previous detention hearing and call for a renewed review of bail and or conditions of release. 1. New evidence has come to light that goes to the heart of the state's allegations that Miss Richins poisoned her husband with fentanyl. The state's case is based on statements made by CL that she procured fentanyl from Robert Crozier on 2 occasions and sold it to Richins. The defense has recently learned that in April of 2025, Crozier met with prosecutors and informed them that this was not true. He told members of the prosecution team that he did not sell fentanyl to Miss Luber, but rather sold her OxyContin. The state's case, from my perspective, and I'm a former prosecutor, so it's easy for me to put myself in that headspace. The state's case is based on Kouri Richins asking person number 1 if he can get her things, and person number 1 being like, no, I'm not procuring you pills or propofol or whatever. Get the fuck out with that, and never speaking to her again. Then going to Carmen and asking her, and Carmen being like, I got a guy. And then Carmen giving something back to Kouri, and then Corey's husband getting very sick. Kouri going back to Carmen and saying, I'm going to need something stronger. Carmen picking up something else from Guy, giving it back to Kouri, and then Eric Richins dying of a fentanyl overdose. That's the heart of their case. Dude saying, no, I thought I was just selling Oxy. I don't know what they put in that shit. Don't come down on me. I want to know what Utah's laws say about fentanyl and how much Utah is coming down on fentanyl. I'm just curious. Because could I see a circumstance where somebody's like, yeah, no, I don't fuck with fentanyl. I was just selling Oxy. That's what I was selling. I wasn't doing any of that. Could I see a jury being like, really? You told them originally you were, then you thought about it and told them that you weren't? Oh, okay. I understand why you'd want to do that when somebody's dead. I understand that, but you gave Carmen pills. Carmen gave pills to Kouri. Eric died. We still have pills, right? Okay. Did you scientifically test them? Were you testing the pills that you got? No? Sure. Okay. I don't see how that goes to the heart of the defendant's case. And I think the jury's going to look at that and be like, okay, so you're saying it's a different type of pill, but you're still selling pills. Sure. I'm more troubled if the prosecution didn't disclose the change of statement. That troubles me more. I don't think it's a material change of circumstance. But let's see. The defense has recently learned that in April 2025, Crozier met with prosecutors for Summit County and informed them that this was not true. He told members of the prosecution team that he did not sell fentanyl, but rather he sold OxyContin. Footnote 1, the statement is also consistent with Luber's original statement that she sold only OxyContin to Richins. Okay. They really might have believed that that's what they were selling. Sure. That doesn't change how he died, though. But sure. Although the state failed to disclose this exculpatory statement to the defense as required under Brady and Giglio, the defense learned of it independently when they interviewed Crozier September 3rd, 2025, at which time he relayed this exculpatory information. Calling it exculpatory doesn't necessarily make it so. Also, I'm really curious about the prosecutors meeting with somebody at a Starbucks. Like, how do you record an interview if you're meeting at a Starbucks? I don't know. I've got a lot of questions. The defense goes on to say that Mr. Crozier has informed the state and the defense that he sold only OxyContin to CL on 2 occasions. He further told both the state and the defense that he did not recall previously telling the Summit County detectives that he had sold fentanyl to Miss Luber at the time of the previous interview, and that he, quote, had been detoxing and was out of it. See affidavit. Crozier, who is now sober, states that he is certain that he sold 30 milligrams of OxyContin pills on both occasions. I mean, I am not an expert in the chemical makeup of OxyContin vis-a-vis fentanyl, but aren't they in the same category of opioid? So, okay. Sure. Mary said, in April 2025, Utah passed a major fentanyl to increase penalties. So new legislation. I mean, fentanyl's a horrible, a horrible drug when used improperly. And the problem is that it is being used improperly and also laced in all kinds of shit that is causing a lot of damage. Andrea says, I live in Utah and they are coming down hard on fentanyl. Terry says, basically, fentanyl is fully synthetic. Oxy is semi-synthetic. Look, here's the thing. Utah coming down on fentanyl, A, is something that the jury is going to be aware of. B, if the laws were changing in April and this witness has not been given immunity, I can see why a witness might say, no, I wasn't fucking with that stuff. I was fucking with the other opioid. Could one understand why someone might choose to change their statement? Perhaps. That doesn't change that the prosecution should have turned this over. 100% should have turned this over. The defense goes on to I don't see it as a change of circumstances. So, argument. Utah code provides that an individual charged with or arrested for a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony when there is substantial evidence to support the charge. Well, we're there. We're there. This doesn't undermine the weight of the evidence in this case in my mind. Although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Mr. Crozier's recantation of his previous statement changes the landscape. Do you see it as him recanting? Or do you see it as him saying, no, I sold pills, like I said, they were just different pills? I see it as a change of statement. I don't see it as him saying, no, I never even went to that guy. Like when I think of recanting, it is, no, I never said that. I was never there. I was never messaging her. I sold nothing. I didn't give them any pills. I did none of this shit. I don't even know them. I wasn't even there. Fuck you. I didn't see shit. This, I think, is a modified statement. I don't see this as a recanting of I never sold pills. He's saying I sold her pills by a different name. I also don't see that as recanting. Artesia Lulu in the chat said, recounting versus recanting. The wit is a 10 out of 10. Also, yes. It is a asterisk. No, I wasn't selling the super fucking deadly one when somebody died. I didn't do that. I didn't do that. So, I just think that this is not the earth-shattering grasp at hope the defense wants it to be. But they can try that, but I don't see it as recanting. Let's see. What is our official definition of recanting according to dictionary.com? Not decant. recant. To withdraw or disavow a statement formally, to retract. It's a change in statement. I am going with it as a change in statement. So let's see. The defense says, although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Mr. Crozier's recantation of his previous statement changes the landscape to a degree that cannot be ignored. Oh, okay. Sure. I don't, that's not a vibe for me. I think that's really strongly overstated. In order to continue to hold Ms. Richins without bail, the court must first find that there is substantial evidence to support the charge, and that simply no longer exists. Sure. They go on to say our Supreme Court has explained that the purpose of the substantial evidence standard in the bail context is to ensure that the quantum of evidence presented by the state sufficiently justifies the denial of the defendant's right to freedom from pretrial incarceration. When I'm looking at this, if we pulled out this entire witness and just had CL's statement, would it undermine the entire case? No. Do you need this witness? No. You don't. Is it a nice to have? Sure. Do you need this witness? No. Kouri's statements to CL and CL's statements back to Kouri are much more relevant than the third party. S Cubed, I agree with you. S Cubed said, I would think the bigger issue is the prosecution withholding evidence. I agree. The prosecution not turning over a change of statement is the bigger deal to me. Because removing this witness entirely, and I bet if the court said to the defense, fine, I will prohibit that witness from testifying, the defense would say, no, we want that witness to testify. It's exculpatory to us. I don't think a jury's going to agree, but the change of statement might be something that the defense can hang their hat on. There is a footnote here. The defense also intends to introduce the 5-minute interview of Mr. Crozier from 2023, where he agrees with the detectives that he sold fentanyl. Okay, good. It's recorded. Both of them should be recorded, and then the jury can decide for themselves what they believe. Sure. Let the jury decide. In this matter, the state's entire theory of criminal liability is that Kouri Richins procured fentanyl from her housekeeper, CL, which she caused to be unwillingly ingested by her husband in some unknown way. No, they said it was in a drink, directly causing his death. There is no physical evidence of this. Okay. I mean, she makes a lot of statements. And the autopsy report is pretty physical. And the law enforcement looks around the home to see if this is an accidental OD. And you know what they don't find? Fentanyl. Anywhere. And they tested all the weed gummies, and there's no fentanyl there. So, and she says she's the only one at the house. And, oh yeah, as Chad is pointing out, Becky RN in the chat aptly says, and what about the Seroquel? Yeah, her prescription medication is mixed with the fentanyl. So, I mean, potato, if you want to not call that physical evidence. I mean, there's also all the texts from your client There's also the I'm going to need something stronger text. I mean, that one's yeah, this is not the serve they want it to be. I understand that they are doing their job to fight for their client. They sure are. They are fighting for their client. We're just not seeing things the same way. Oh, we didn't even talk about all the Google searches and the other text paramour and the deleted shit off the phone. How's long till the judge denies this? I think the judge is going to tell the prosecutors, what the fuck are we doing not turning over witness statements? I think the witness statement issue, not turning over a witness statement, is the bigger problem for me in all of this. Do I think it's going to fundamentally undermine the weight of the evidence against Kouri Richins? No. And if this witness is called at trial by the defense, it's going to be oh no, I sold different pills. And the jury's going to be like, but you still sold pills, right? And then he died? Okay. And then it's going to be a blip. So I also don't see this as recanting, but then again, I can understand why they're arguing it, because you take the thing and then you make it bigger and then you pound on the table. The defense goes on to say none of the so-called fentanyl pills were found nor tested. The victim was tested. And then there's the text messages. So she asked for fentanyl and then he dies of a fentanyl overdose. So, I mean, I realize that that's circumstantial evidence, but there's not a lot of dots on that line. None of the so-called fentanyl pills were found or tested. CL only believes she sold Kouri fentanyl because she believed that is what Crozier gave her. Okay. Footnote 4. CL's original statement was that she never sold fentanyl to Miss Richins and that Miss Richins never asked for fentanyl. Only later did she change her story to say that she did get fentanyl from Crozier and then gave it to Kouri. Chat, let me know, because I see this through the lens of a prosecutor, and I'm curious as to what you think. And if you are replay crew, love you. Put it in the comment section. If they all thought that they were selling OxyContin instead of fentanyl, does it change all of this for you? If all of them came in and said, she was asking us for fentanyl and we sold her these pills and they were oxy, does that change any of this for you? What they thought they were selling? Because if they bring in the other guy, he's going to say, oh, I went to a guy and said, can you sell me pills? And then he sold pills to Carmen, and then Carmen gave pills to Kouri. The text messages say what the text messages say. She was asking for propofol. She was asking for fentanyl. She was asking for back pain. She was asking for whatever. But it doesn't change the autopsy, does it? And it doesn't change that she was asking for something stronger, does it? No, it doesn't. I'm not really bothered by what they all thought they gave her. Right? She wanted opioids. What you call the opioid doesn't really ruffle my feathers at this point. So, the defense goes on to make the leap. I mean, they are like walking a parapet in a storm at this point on unsuccessfully. They go on to say, if Crozier did not in fact sell fentanyl to Luber, then there can be no credible argument that substantial evidence of guilt exists. I mean, I couldn't disagree more strongly. And I think saying that it's so isn't going to make it so, but okay, defense. Sure, A for effort. They go on to say, and since a criminal case, a jury must find the defendant guilty beyond a reasonable doubt, the substantial evidence standard is met when the prosecution presents evidence capable of supporting a jury finding that the defendant is guilty beyond a reasonable doubt. Even though the prosecution's case need not be airtight, and the defense must do more than have poked holes in the state's case, there must be evidence that supports the elements of the crime charged. That is not the situation before this court. Brad Bloodworth is going to file, I would imagine, a fairly snarky response, lining out all of the things that we have talked about today. Oh, would you like me to illuminate the substantial evidence again? Sure. We can illuminate the substantial evidence again, starting with the fact that your client said, I don't know where he would have gotten fentanyl into his system. It must have been the gummies, and we tested the gummies and it wasn't there. And you said you mixed him drinks and it was orally ingested. And. And I hope that he includes the text with the paramour where she is telling the paramour, we can be together, just hold on for one more day. Hold on for one more day. She's like, hold on till Friday. We can be together. And then after he doesn't die on Valentine's Day, ask for something stronger. Oh, I don't know. So weird. But sure, the guy who's selling the illegal things at the gas station saying that illegal thing was not the big bad illegal thing, but was the less big bad illegal thing. Sure. Sure. I could never, ever in my life think of a reason why someone might want to distance themselves from selling the thing that the state is completely cracking down on. I could never imagine why someone might want to distance themselves, especially if they don't have immunity from the prosecution. I mean, at that point, it's just survival, right? Excuse me, I'd like to not go to prison forever. Sure. Nightshade Winter asked, did the paramour know she was going to kill her husband? I have no indication of that. I can only imagine that the paramour thought she was leaving her husband. We've seen nothing beyond that. So the defense goes on to say that if the state cannot place fentanyl in the hands of the defendant, the state has no case. She has pills in her hand that are never tested. And then her husband has them in his body. So I don't care what the non-scientific testing of the pills say that the pills are. Because the circumstantial evidence that the pills that she got are what she put in the drink and gave to Eric, because there's no fentanyl in the house that he would have ingested. So they think that this change of statement in the hyperbole of the defense, if the state cannot place fentanyl in the hands of the defendant, the state has no case. Mr. Crozier's statement does not just poke holes in their case, it throws a grenade into the middle of it, leaving them with nothing but speculation and conjecture, getting them nowhere near the realm of beyond a reasonable doubt. Are you reading the evidence in this case, and do you believe what you are typing? I feel like the defense wants the fact scenario that Karen Reed had, and are trying to make it happen and can't make fetch happen because there's too much evidence. These things are not the same. They go on to say, without substantial evidence to support a charge of aggravated homicide or attempted aggravated homicide, the analysis ends and Ms. Richins should be released. That's not going to happen. I do think the court's going to be mad at the prosecution if they didn't turn this over. If they did turn this over, I imagine they're going to say it. But I'm curious. You know what we need to do next? We need to go look at the affidavit. I am saddened that we do not yet have the prosecution's response. When we do have the prosecution's response, I am going to be so curious to see what they have to say because I want to know. I'm going to see if I'm going to update the docket. The CAPTCHA is making me CAPTCHA again. I mean, why are there so many CAPTCHAs on this website? It's a docket. Like, calm down. Oh, it's because if they log you out, they can charge you to do the search again. It's just money, Emily. Duh. Follow the money. And yes, every time you go to pull up a case, it charges you to pull up the case, which is why I do it so you don't have to, because ew. It's not as much as California, but more than others, more than Pacer. So I'm going to double check the docket again because we're like an hour later. We'll see. Let's pull up the affidavit and see what the affidavit the defense submitted says. Because, well, that will kind of close the loop on the rest of this because we've already done the amended complaint. So let's make sure we have the affidavit of Robert Crozier that was submitted with the request for bail. I don't think that request is going anywhere. Let me just scroll down to the bottom of this docket because you never know. If something gets filed, I will tell you guys in the Lawnerd app, still nothing. Boo. But I'll keep checking because I'm real curious. We know what Bloodworth is going to say is going to be spicy, but it's probably not going to be till next week. Maggie P said, Emily, what happens if the prosecution did hand it over and the defense didn't look at all the evidence? Then it's a misunderstanding. Will the defense get in trouble? No. If the defense is like, this was in a 15-page thing titled this other thing and we didn't know, no, the defense won't get in trouble. You know, they'll bring the motion. They say that they had no notice of it. They say they have no notice of it. We'll see. I'm curious as to what the state's going to say. I'm curious as to how we get to, I think it's a reach to get to this as exculpatory, but it is a change of witness statement that should have been turned over. I want to know more about that circumstance. So, Magnus said, what if they had notice of it? If they had notice of it, then the court's going to say, this isn't exculpatory. They turned it over to you. There's no remedy. This is all just moot. So we'll have to see. We'll have to wait and see. It's possible that there was a change of witness statement and the prosecution's like, oh yeah, we never uploaded that into the portal. Our bad. Here it is. That's possible. And this far before trial, the court would say, I imagine something to the effect of, go double check that there isn't anything else, please, before this goes to trial. But the witness was on the witness list such that the defense went and interviewed the witness. Ellie Mae said, what happens if the witness said they told the prosecution, but it wasn't true? The prosecution will say, this isn't true. Here's a recording. Or this isn't true. This is the other witness that was at the interview. Yeah, that's what they will say. Does that happen? Yep, it does. It absolutely does. I told the prosecutor this, that. No, you didn't. And so we'll see. Let's pull up the affidavit. I think this one's worth a swoop. Because why not? We haven't swooped enough today. We've done lots of bells, not enough swoops. I love how easy these are to see. Hold on. This is the affidavit. Oh, I embiggened it improperly. Hold on. Let's do it that. There we go. Now I can wiggle it just a little bit. Ooh, it's a musical day today. ADHD is ADHDing. The defense presents the affidavit of Robert Crozier. Affiant being duly sworn states and deposes as follows. My name is Robert Crozier. I'm currently residing at the Davis County Jail in Utah. I'm over the age of 18 and have personal knowledge. I have been identified as a witness in the above stated matter. In that capacity, I've been interviewed on 2 separate occasions by individuals associated with the prosecution of Kouri Richins. I have been told that the first interview was on or about May 4th, 2023. That's 4 days before the arrest. It was conducted by 2 officers from the Summit County Police Department at the Davis County Jail. So he was in jail at that time too. When did he get out of jail and go back to jail such that he was at a Starbucks? Robert, I have questions. Because if you're in Davis County Jail now and you were in Davis County Jail then, when were you at the Starbucks? I have a whole lot of questions. I have been told that the first interview was on or about May 4th, 2023. It was conducted by 2 officers from Summit County Police Department at the Davis County Jail. I do not know the name of the officers. On May 4th, I had been in jail for a short time and was detoxing from drug use. Okay. I do not have any personal recollection of the details of that interview, although I have since been told that I agreed that I had sold fentanyl to Carmen Luber in 2022 on 2 separate occasions. In early April 2025, I was asked to meet with 2 people from the Summit County Attorney's Office. I believe that both individuals were prosecutors, and they told me they were prosecuting Kouri Richins. I believe that one of them was Brad Bloodworth. I mean, who forgets Brad Bloodworth? The name, the voice, the man, the myth, it is a memorable name. I cannot recall the name of the other individual who was at the meeting, but it was a man with a beard. And handwritten in, it said, I was sober at that meeting and had been sober for over 3 months. Congratulations on your sobriety, Robert. Keep going. It's a journey. You've got this. It goes on to say, we met at Starbucks Coffee in downtown Salt Lake City. I believe it was the Starbucks on 80 South Main Street in Utah. Mr. Bloodworth and the other individual asked me if I sold fentanyl to Carmen Luber. I told them no. I sold OxyContin to Carmen Luber on 2 separate occasions in early 2022. I told them I met her at the Maverick and Draper both times to sell her the pills. So the only thing that has changed is what he believes the pills were. That's the only thing that's changed. Different type of opioid. This is not recanting an exculpatory. This is a change that should have been turned over and has been discovered prior to trial. They asked why I previously told the officers I sold her fentanyl. I told them I did not remember saying that, and I had been detoxing during the interview and was quote unquote out of it. I told them I was certain that I had sold OxyContin 30 milligram pills known as Roxy's or Roxy 30s. They asked me several times if I was sure. I told them yes, I was sure I sold her OxyContin. I told them at the meeting, I was told at the meeting I would be called as a witness in this case at the Summit County Attorney's Office, and that the Summit County Attorney's Office would be putting me up in a hotel near the courthouse. They didn't mean the jail, sir. They would get you a hotel near the courthouse if you weren't in custody. But now in custody. This is dated the 10th of September and notarized and signed. And why is there a second? There's a second affidavit. Oh, when is this one from? 10th of September. So there's 2 affidavits? Let's read affidavit number 2. My name is Robert Crozier. I'm residing in Davis County Jail. I'm over 18. In early 2022, I was contacted by my friend Nicole Cummings, telling me that a friend of hers by the name Carmen was looking for some pills and would be contacting me. I'm so glad we went through the probable cause affidavit attached to the information, because the witness 3, 4, 5, 6, 7, 8, 9, 10 is now getting filled in from the other side, the other perspective, not from the perspective of law enforcement, but from the perspective of those involved in the transaction. So we have heard from law enforcement's recounting of what Carmen had said. We have not heard this. In early 2022, I was contacted by my friend Nicole Cummings telling me that a friend of hers by the name of Carmen Luber was looking for some pills and would be contacting me. Soon after, I received messages from Carmen asking to purchase some pills. On at least one occasion, she told me she wanted Roxy 30s, and on at least one occasion, she said she wanted blues. I understood this to mean that she wanted 30 milligram Oxycontin pills. In early 2022, I knew the term blues to mean Oxycontin. I did not associate the term blues with fentanyl until late 2022. So you're telling me that it could mean either? And you don't remember anything you said to law enforcement, but that you know for sure that in early 2022, the term blues meant oxy. But later in 2022, you started believing it was associated with fentanyl. Okay. But either way, you sold pills to Carmen, who gave them to Kouri. You didn't chemically test them. So I wonder which has a higher street value. I would guess it's Oxycontin. And I would be curious to know if Carmen was being, if Kouri was being charged for Oxy and sold the cheaper of the two because they perceived that Kouri had the money to pay whatever. I'm just wondering if that's what was going on. I'm also curious if they're going to bring in a law enforcement officer to talk about whether or not people refer to Oxy as blues, because I've only seen it be white. But what do I know? I haven't been prosecuting while the fentanyl crisis gets out of control, because heroin was getting out of control. Fentanyl seems to be cheaper. Kate P said, so did he ask his suppliers for blues thinking they were Oxy and maybe instead got Fent and sold that, meaning he thought he was selling Oxy but actually sold Fent? Yeah, it's very possible. It's incredibly possible. It's also possible that he asked for and thought he was selling Oxy and it wasn't. It's also possible that he's saying, I was not involved in the bad one. That dude died of fentanyl. I didn't sell fentanyl. I didn't sell the thing that caused the person to die. Because there are times when the dealer can also be charged. So I'm interested to see how this all works itself out. We'll see. But also, yeah, could multiple people have different understandings of what blues means? 100%. None of them are talking about Blues Clues. But when this happens at trial, everyone's going to be playing Blues Clues with who meant what about what. She said blues. I thought blues meant this. Sometimes blues mean that. None of us really know. Thank you, the dash in between Matt Bond. Matt Bond said Oxy 30 instant release are blue. I didn't know that. You could actually have a reasonable misunderstanding of how everybody's referring to everything. for sure. In early 2022, I knew the term blues to mean oxy. I did not associate the term blues with fentanyl until late 2022. I met with Carmen on 2 separate occasions in February 2022 at the Maverick and Draper and sold her oxy. The first time I sold her 30 pills. The second time I sold her more than 30 pills, but I can't recall how many. These were the only 2 times I met Carmen. I did not know her before she contacted me, and I have not had contact with her since February 2022. I began selling fentanyl at the end of 2022. In May of 2023, I was arrested for, it says selling fentanyl, but then it said possessing fentanyl. It was changed, and was in Davis County Jail. At that time, 2 officers from Summit County Police Department interviewed me. I do not remember their names. I was very confused during the interview as I was detoxing from drug use and was very out of it. That is entirely possible. That is why they should record these and video record them so the jury can decide. At first, I did not remember Carmen, but after they reminded me, I did remember that I had sold pills to her and that she was a friend of Nicole Cummings. I don't remember the details of the interview, but I have since been told that during the interview, I agreed that I had sold fentanyl to Carmen and that blues refer to fentanyl. It is my belief that I agreed I had sold Carmen Luber fentanyl because I was personally detoxing from fentanyl during that interview, and by then had been selling fentanyl, which I had come to know as blues. It's completely plausible that it's just there might really just be a misunderstanding of what was sold. I don't think, A, that's difficult to clear up, and B, I don't know how much it matters. Did you sell pills to Carmen? Yes. Did Carmen ask you for pills? Yes. Did Kouri ask Carmen for pills? Yes. And you sold Carmen pills? Yes. And then Carmen sold the pills to Kouri? Yes. And then Kouri the first time asked for stronger pills, and then Carmen came back to you and got more pills? Yes. And then you gave them to Carmen? Yes. And then Carmen gave them to Kouri? Yes. And then he has fentanyl in his system when he dies. I mean, okay. It really becomes a matter of the medical examiner explaining opioids and maybe a cop coming in to talk about street lingo, and that's about it. But it doesn't change the pills that are bouncing hand to hand, because none of them are going to chemically test any of this. And it seems that there is potentially a very real misunderstanding of language or distancing from like, no, we didn't sell the thing that killed him. Okay. Sure. But this is all, I got a guy who 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 really knows what's in any of it, which is why it's so fucking dangerous. The affidavit goes on to say I am currently in recovery, and although I have relapsed during my recovery, at this time I have been sober for about 3 weeks. Prior to my relapse, I had been clean for 9 months. Keep going in your recovery, sir. This is not going to be a huge deal. It is going to be fine. Do not let people stress you out. Do not let anybody stress you out. Keep going after your sobriety. This shit is dangerous. Be safe. But I'm sure there's video of the first interview. I don't think this is going to be the earth-shattering issue that the defense wants it to be. Because I think all of it is, well, reasonably explainable. Stay safe. Keep going on your sobriety. He goes on to say, I did not sell Carmen fentanyl in February 2022, but sold her 30 milligram OxyContin pills. In early 2022, I was not selling fentanyl and did not have access to fentanyl. Rather, I was selling my own OxyContin prescription, which were 10 milligram pills. If a buyer wanted stronger pills, I had a source who provided 30 milligram OxyContin, which is what I sold. But do you know where they got them from? And do you know what was in them? No. Because what ended up in Eric Richins was fentanyl. And that is one of the things that is so scary. You do not know. So he said if a buyer wanted stronger pills, which exactly fucking lines up with what the prosecution is saying. The prosecution is saying that in February, Kouri got something and that opioids can cause the hive reaction. And then Kouri wanted something stronger. And then Carmen went back and wanted something stronger. And he is saying, if a buyer wanted stronger pills, I had a source who provided 30s, and that's what I sold. This seems fairly consistent that stronger opioids were sold. Okay. He goes on to say Roxy's or Roxy 30s refers to 30 milligram OxyContin pills. To my knowledge, blues also refer to OxyContin until late 2022 when I came to know the term as also being used for fentanyl. I did not acquire a source of fentanyl until the end of 2022. The fentanyl pills that I began selling at that time were very dark blue, almost purple. In April of 2025, I was interviewed by prosecutors with Summit County Attorney's Office and told them I had sold OxyContin to Carmen and not fentanyl. I certify that this is true. Okay. So I am curious to know when the second interview got turned over. That is the thing I am most curious about. Is this a recanted statement? I think it's a clarified statement. A recanted statement would be, I didn't sell anybody shit in how I see a recanted statement. I'm curious as to why the defense says that they don't know that there was an interview in April. That should be turned over. Okay. So, where are we at the end of the day with the Kouri Richins case? The defense is asking for bail. The defense is asking that the court force the prosecution to turn over, witness statements, which they should be doing anyway. And the defense has posed that there was an updated witness interview in April 2025 that was not disclosed to them. And they did not discover that the witness had been interviewed until they went and interviewed that witness in September, because that witness is on the state's witness list. The defense says that the witness recanted their statement, and this, they literally use the word, throws a grenade into the state's entire case. I do not see it that way at all. The defense used a lot of hyperbole in their argument, but the changed statement is that the go-between from Kouri Richins to a dealer went to the dealer and procured pills of OxyContin and not pills of fentanyl. That is what the dealer is now saying, and saying that in their original interview, they said they sold fentanyl, but at the time they were in custody and were detoxing from their own fentanyl use and were, in their words, out of it during that interview. But that is also a recorded interview, so the jury will get to decide for themselves. They also said that in early 2022, they referred to Oxy as blues, and in late 2022, they referred to fentanyl as blues, and that at least one point, Carmen had asked for blues and at one point had asked for OxyContin. What we know about Kouri's case in this part is that before the attempted murder charge from Valentine's Day, Kouri had reached out to two individuals, Carmen and another individual, asking for pills and then asking for Michael Jackson stuff and saying that she needed them for a client for back pain. And that the first person was like, no, click, and they never spoke again. The second person, Carmen, reached out to a friend who put her in contact with a friend who met her at the Maverick and Draper and sold her pills. And those pills she gave to Kouri. And then on Valentine's Day, Eric Richins got so sick that he told his friends that he almost died, broke out in hives. When he reached out to Kouri and said, I think I might have to go to the hospital, but I think I'm going to take a nap. She said, yeah, take a nap and let me know. And then after that, Kouri reached back out to Carmen and said, I'm going to need something stronger. And then Carmen reached back out to the dealer and said, I'm going to need something else. And then the dealer gave pills to Carmen that they are now saying was oxy and not fentanyl. Those went to Carmen. Those then went to Kouri. And Eric Richins died of a fentanyl overdose on March 3rd. So if the dealer who is giving pills to Carmen says that those pills weren't fentanyl and they were oxy, is that exculpatory? I don't necessarily think a jury will see it that way. I don't think it undermines the case based on Kouri Richins' own statements and requests. And it will be interesting how that comes out in evidence. Because at the end of the day, the witness said, I sold pills. But they were this type of pill, not that type of pill. It will be interesting if the prosecution adds a law enforcement witness to explain how things on the street are laced. We'll see. But I'm most curious about the change of statement not being turned over to the defense. When that statement was changed in April of 2025, it should have been turned over to the defense. What are the potential outcomes from that? Well, it's known now. The defense went and interviewed the witness who's on the witness list, so they are aware. So we'll see what the court has to say about that. The prosecution hasn't responded to these allegations, hasn't responded to the defense's allegations that a critical witness in this case has recanted. I don't see it that way when we look at the facts. And in fact, this witness said in their statement, at the time I was selling my own prescription pills, but if somebody wanted something stronger, I had a guy that I could go get 30 milligram pills from, and that's what I did to give to Carmen the second time. So the Kouri asking for something stronger, Carmen asking for something stronger, Carmen asking the witness for something stronger, the witness procuring something stronger, giving it to Carmen, who gave it to Kouri, who gave it to Eric as alleged in this case, all lines up. The only one thing is different is that that individual is saying, no, it was a different kind of opioid. I don't see that as recanting. The defense very much wants to make that happen, and in fact said that this was such a substantial change in the weight of the evidence that Kouri Richins should be let out on bail. I don't think the court's going to see it that way, and I think this has opened the door for the prosecutor, Brad Bloodworth, who really doesn't pass up an opportunity to lay out the facts of a case. I think this opens up the door for Brad Bloodworth to again lay out all of the evidence against Kouri Richins, which we reviewed in substance in the updated fourth information, which included new information from Kouri Richins' journal. And we took a look at that updated information in the updated probable cause statement on the fourth amended information, which is the one they're going to be going to trial on. It cleans up the charges. Remember, the prosecutors took out a number of the charges and put them into the financial prosecution. There is a separate financial prosecution in addition to the criminal homicide prosecution. So that fourth information is cleaned up with those charges, removes those charges, and the court had already separated some of those at the defense request, and the prosecution had already dropped two of the charges, which probably shouldn't have been filed in my opinion, but have been dropped. So the fourth information is cleaned up and does add new information. So is this a recanted statement? You're going to have to let me know what you think. Does this throw a grenade into the prosecution of Kouri Richins? Not even close. Is this a substantial change of circumstance that changes bail? No. Do I think the court will want to know why a witness statement from April wasn't turned over? Absolutely. The court's absolutely going to want to know that, and is going to say to the prosecution at some point, you need to make sure there's nothing else. This case is set to go to trial in February of 2026. We will see if the court allows it to be streamed in real time or on a delay or on a day's delay or whatever. But the court has allowed there to be some filming of the case. And so we are going to see what that looks like as we get closer to February. So with all of that, Kouri Richins should be going to trial in February, and I don't see the state of the evidence as being greatly altered. Let me know what you think. Law Nerds, we need to get to questions. We need to get to questions. You've got questions. I've got questions. We're going to do some questions, and then we are going to try to see what changing to like an after party looks like. We're going to see if we can do that, because that seems pretty cool. But we're going to answer some questions first. Patty says, are we going to watch the case? However we can, yes. How that's going to happen, I don't know. But we're going to try. We're going to try. But we are going to test out some new tech. I'm going to get to a few questions. And then I have just got a headache that is fighting with me. So it's not going to be long today that we are doing that. But I'm very interested to try out the new tech. So we're going to try that. We're going to see if we can after party. We're going to give it a try, but let's answer some questions first. Miguelina told me that people were asking about the lip gloss. It should have been linked, but I don't even have it. The one I have today was the one that I normally link from. Let me go take a look real quick. I think it is in the, it is linked in some of my other videos. Let me just go check real quick because it should link to Sephora. Let's see. It should link there. It is the lip gloss stain is what I was wearing today. And I believe I was wearing the color raisin, but sometimes it is the other one. I have two that I very much like, the Kulfi, that is linked under a lot of my videos that takes you to Sephora. So Kulfi, the lip staining, long-lasting lip oil. Today, I'm pretty sure I was wearing that in Fig, but I also wear that in the color First Sorry. I switch between the two. And let me see if I can make sure that that is linked in my YouTube studio. Miguelina can double check that, but those are what I was wearing today, was the Kulfi when I started stream. So that will be linked through Sephora. If you go through our link, we do get an affiliate commission on that. If you just go purchase it, then you can just go purchase it. But let me go link it real quick. Miguelina, I can just link it in the YouTube studio. Also, the thing that is helpful when you link through the shop section is we can also let our brand partners know how many law nerds are interested in certain things. Because I honestly, this is just, it's just a few of us on the internet here chatting. I use that to try to leverage discounts for y'all. And I go, hey, look, this is how many of you were interested in the thing. Can we get the law nerds a discount? Every single time. So that is what I was wearing. Sometimes it'll take you just to the one shade and you have to flip through the shades and find the one that works best for you, because what might work for you might not be what works for me, but I tend to stick to berry colors. So berries, deep plums, anything that can look like Linkin Park After Dark on my lips. That's what works best with my skin tone, but I am very fair. So that's what works best for me. Pretty Mama Bear asked, will I be linking the flannel? Yes, I have to find it, but I will link it. So So that we will clean up. Femme Dandy said EDB has cool undertones. Oh yes. We are very much a cool toned girl for sure. So I tend to link cool tone berries, but I really enjoy it. Find the color that works for you. It's buildable. It does stain pretty well and holds the lips. I really like it. So Tish in the chat said, do you think she'll try to plea out? I don't think there's anywhere for her to go. Then again, there wasn't really anywhere for Kohberger to go either. I don't think Kouri's going to try to plea before every single legal decision has been made. I don't think she should. I think she should wait until all the legal decisions have been made. She's facing life. I can't imagine that the prosecution is going to offer her anything less than that, given the circumstance. And she's facing other cases. And she gave some kind of a jail call from custody interview saying, hey, this is all wrong. I am being wrongly prosecuted. They are going after a mother. It was fairly appalling. We didn't go through a lot of it. But I don't think she appreciates the circumstance that she is in, perhaps. So I don't think there's anywhere for her to go. They're not going to reduce this to not a life case. This is a life case. If the things went the way that the prosecution is alleging, if they did go down that way, then this was a very intentional, calculated domestic homicide for pecuniary gain. That would qualify as a death penalty case. This did qualify as a death penalty case. They are not going over the death penalty or going for the death penalty in this case. But that the attempted murder followed up by the murder, followed up by the uncovering of financial fraud, life insurance fraud, mortgage fraud, taking out life insurance on him while she was alleged to be in the planning stages of this. This is not a split decision. This was a calculated, it would be better if he was just dead. Let me make that happen if this happens the way it was charged. And then what did she do afterwards? Deleted shit off her phone and wrote a children's book about grief and was on a book tour selling her children's book about grief. And then she was arrested. No. So I don't know where she can go. I don't know where she can plea. I don't know. Put me in federal custody. Nope. Give me some Crest white strips. I don't like the way my teeth look on TV. Nope. Nope. Jilly Bear, thank you so much. It's good to see all of your member chats. Some of you are saying you're having trouble with the link on the video. I have no control over that. Sometimes we break things because we're law nerds and links break. So apologies, sorry, and I'm sure it will be fixed. We're not going to, well, hopefully we're not going to break Sephora. I mean, sometimes it happens, but hopefully we have not broken Sephora. But we also, you know, if you want to test if your lip gloss stays on while you have a croissant, we've also got Wildgrain for you today. So Sephora not sponsored, just an affiliate link. Wildgrain sponsored, also the lifeblood of my desire to be a pastry chef without the time. So just frozen into the oven, crispy pastries, makes me happy. Love it so much. Okay, let's see. Ashley said, Miguelina, I think we need to screenshot because it does. We are working on the sizing of our chats and they are definitely They've gotten larger and more readable, but also they are maybe a little too large. Ashley, that's not on you. This is just a good example. Ashley said, I'm just popping in to say I'm watching an older trial that I missed at the time, slogging through Alec Murdaugh, and it's killing me that I can't interact. I keep instinctually trying to comment. I know it's really hard watching the old lives and seeing the live chat and not being able to jump into the conversation. I absolutely get it. Chronic Shock said, my membership is a whole baby old. Been looking forward to this one for an embarrassingly long time. 9 months. We have some updates too to our member icons that are coming. I'm really, really excited. Really excited. Lee C said, EDB, loved meeting you in Vegas. That was so much fun when we did the meetup in Vegas around BravoCon. Any chance of another Vegas meetup? I need it for my 2025 EDB bingo card. I have not looked at all of my travels surrounding BravoCon. I don't know if we're going to be able to make that work, but we will see. We will see. Loch Nessie said, if I followed correctly, witnesses claiming he got the oxys from another party, correct? Yes. Who is to say it was oxy if it was not tested? Correct. This was a clarification from the witness wanting to clarify what he assumed he sold. I think so too. Or wanting to just back away from the fentanyl. Back away. Because then it's like, hey, I didn't sell that. And if somebody gave it to me and lied to me, I don't know. I don't know. The dash between with Matt Bond, I will for sure once I check in with the kids. Matt said if it was proven the marijuana stuff couldn't be taken orally, the propofol, how did she intend to give it to him? Because I think she didn't know. I think she didn't know what she was asking for. I think Kouri was just like, propofol killed Michael Jackson. Can I get some of that? I honestly don't think, I think like Scotty doesn't know. I really think it was just like, I don't know. I mean, what can I get that's deadly? I don't know. That's how I see it, for sure. She just really, really didn't know what she didn't know. Yeah, didn't know. Let's see. Sacral said her Google searches about how much fentanyl are just so damning. Yeah. Yep. Molly Pop said, I'm here for the generational pop culture references with a side of law. That's exactly what it is. And Lyndon has taken it to Meatloaf. I will sell my substances for love, but I won't sell that. 52 months, Matt Bond. That's so exciting. We do have some updates. Can't wait. Lorraine said, question, can I just say hi from the replay crew that caught a live after months? Yes, of course you can. Of course you can. Tracy said, EDB, they are chin ticklers now. They really are, but that's okay. If you guys can read them better on mobile, we'll figure it out. Lucy said, let's not forget that Kouri was happily buying a $2 million project house 3 days after he died. And throat punching her sister-in-law. Wild. Living one step at a time said the DA is probably waiting to hear from the Lawnards in order to know how to respond. I don't think that's true at all. Mr. Bloodworth seems to be a very seasoned and astute prosecutor. I don't think Mr. Bloodworth needs our input because remember, just for those of you that are new to this, remember that when the attorneys were arguing over the walk the dog letter and over some of the jail calls, Mr. Bloodworth took the opportunity to just drop a dime on what Kouri was saying on the recorded calls. And just be like, no, she's on these recorded calls calling Sky a bitch. She's on these recorded calls doing this. She's doing this, that. He took the opportunity to be like, let me tell you what. So no, that's already there. I think he's just like, let me tell you what. And the defense opened the door to all of the arguments of, oh, there's not substantial evidence. Let me remind you. This is how you remind me. Let me remind you of all of the evidence. And then let me ponder why somebody might say, oh, I was selling this, not that. Also, does it really matter? Also, why would dude at the Maverick and Draper, would he know that what he got wasn't laced? Also, Kouri was asking Carmen for something stronger. Dude said, I went to my guy to get something stronger. Okay. Sure. Emily said, why does knowing that Kouri just like asked for anything make me even angrier? I really think she did. Leslie said, is this actually live? Yeah, we're live. Pre-recorded content today? I don't know what. No. Pre-recording content, honestly, is more draining for me than being live with y'all. For the members that have been in the BTS of me trying to record the podcast, it's just half podcrastination. Because sitting down to pre-record content only goes up on the Emily Show channel with the podcast on Mondays, and then the breakdowns of these cases. So that goes up on the Emily Show. All right, Law Nerds, let's try out some of the new toys from YouTube. Let's see. We can set... I don't know how this is going to work, so we'll find out. But we can after party it with our channel members. Oh, and I can choose how many minutes. I can choose if we start in like a minute or 5 minutes. Let's do 5 minutes. Emily needs time to say goodbye. So we'll see. I don't know how that's going to work, but I guess for all of you that are members, we should just transition into a members only video. We'll see how the countdown goes and see if I'll be able to roll the outro. I don't know if we can. Court, we are going to go back and cover the Cardi B attorney. We are just not doing it today. There was so much going on that I wanted to make sure that we were taking a look at the stuff that was a little bit more pressing. I also saw a lot of headlines that I was curious about. I wasn't sure if they were misleading or not. I wanted to see if a witness had recanted, and I was too curious to wait. So we popped into the Kouri Richins stuff because it's a case we've been following for so long. But we will pop back to take a look at the attorneys getting sanctioned and stuff. I don't know if mobile is seeing a countdown. Let's see. What's on the members agenda? We're just playing with new toys. We're going to do more of a members only later this month, but we're going to do, we're just going to see how it works and if it works. So we're going to see how it rolls. JJ asked about app members. We have not used this feature before, so we're testing it out. We're going to see how we can make sure that all of our members get there, but we're going to see. Lyndon says there's a teeny unobtrusive after party timer. Perfect. So we will see how it works. But app members, we are going to be doing a full members only. I just want to see how this works and if it smoothly puts us into a members only stream and if it's something we can use in the future. So we're doing a tech test today. So that's what we're doing. We are tech testing. On mobile, we have a countdown timer for members only. Exciting. So we're going to tech test it and see what happens. That's all. Jen V says she feels very guilty. Can't wait to hear the excuse. I mean, Kouri Richins does strike me as someone who may consider testifying in their own defense. I think her attorneys will probably advise against it. Given all of the jail calls and the walk the dog letter and the rest of it, I want to know how the walk the dog letter is going to come in because I think we're going to see it come in. So for those of you saying take care of the headache, don't worry. We 100% will because we're going to tech test and then we're going to go take some Advil. Adcomet, good to see you, said my membership is a whole 3-year-old, but we refuse to stop counting in months. YouTube. That's YouTube. They at 37 months. I know. I don't know. On the back end, sometimes they show it as like 1 year, 2 year, 3 years. Sometimes they don't. I told them we need more differentiation. We need more like gavels and prizes and stuff. I think there's a lot of fun stuff we can do with it. I'm really interested to see how this works. So we'll see. We've got like a minute and 30 seconds. Victoria said, I love how you perfectly describe what I'm thinking. Victoria, thank you. That is so sweet. Law nerds, for those of you that are members, we will see how we end up in another dimension. For those of you that are not, stay tuned in the Law Nerd app. I will be back next week. My kids are out of school this week, so we're spending some family time. We have lots to cover next week. I will be back to cover it all. If the prosecution files this week, I'll give you a quick update in the Law Nerd app and a little like the prosecutor said this, but we'll go over it because this week, some needed family time with the kids being out of school. So Law Nerds, take care of yourselves, take care of each other. It's good to see you. Replay crew, happy to see you. Glad everything's timestamped below. I can't wait to see your answers on this one. But members, we will see how we boogie on over. I'm going to roll the outro and I'm going to run to the restroom. So if it goes to a blank space for a minute, don't worry, I will be back. I'm just letting you know where I'm going. So we're in the final countdown. We'll see what happens at members. We will see what we can do in the app. We are tech testing. So we're going to figure out how things work and why. Law Nerds, thank you for being here. Thank you for being a Law Nerd. I will see you in the next one, or I'll see you in just a moment. It depends. I guess we'll see what happens. Into the unknown, Law Nerds. Let's go. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free